Honor. Good morning, everyone. This hearing is in the matter of CFI 043-2020 and is being held by way of video conference before Justice Wayne Martin. Any orders or directions made during or after the conclusion of this hearing will be issued on the judge's instructions by the registry. Counsel for the claimant is Ms. Zoe O'Sullivan. Counsel for the first defendant is Mr. Martin Koshtel. Counsel for the fourth defendant is Mr. P.B. Shaheen. Thank you.
Good. Thank you. Ms. O'Sullivan.
Your Honour, good afternoon.
Did she say different number for?
There's a little bit of background noise, I think. Someone has their...
Yes. Mr. Shaheen, I think you should be on, if you're going to speak, you should need to go on mute.
Thank you very much. Your Honour, have you had the chance to read the skeletons?
Yes, I have, thank you. I've read the case bundle, at least last week I had access to the case bundle, so I was able to read it. I can't say I'm familiar with every document in it, but I'm certainly familiar with the issues.
Thank you very much, yes. So you would have seen from my skeleton, this is a bank's application for immediate judgment in the sum of approximately $30 million against both the principal debtor, NEOPHARMA, and the guarantor, Mr. Shetty. And this case is perhaps unusual amongst the many claims brought by various banks against Mr. Shetty on his personal guarantees, in that the principal debtor is an active party and not one of the companies which is insolvent in the ADGM. The second and third defendants are in administration in the ADGM, and the claim has been stayed against them as a result. Your Honour, this is what you might call a plain vanilla debt claim against the principal debtor and the surety which guaranteed repayment of the debt. All that the bank has to do is prove that it advanced the money, that the money has not been repaid, and that the full principal plus interest is due and owing. It is entitled to judgment against both defendants and to choose against which of them it wishes to execute the judgment. Now, as Your Honour knows, both defendants are objecting to the admissibility of the second witness statement of Mr. Chauhan for the bank, which was served on the 4th of January. So what I'm proposing to do is set out the bank's case without reference to that statement, and then at the end ask you to make a ruling as to its admissibility.
Well, wouldn't it be better to do it the other way around and invite a ruling as to its admissibility? Because if for example, if my major concern is prejudice,
yes,
then that prejudice could be cured by an adjournment.
Well, quite. Okay, absolutely. Okay, in that case, so essentially, the statement of Mr. Chauhan, which we should have a look at it, it essentially relies on documents. The statement itself is simply drawing to Your Honour's attention the payment instructions and supporting documents received by the bank from NEOPHARMA when it was drawing down on the loan. Can you
help me? Where is it in the bundle?
Yeah, I can help you in one moment when I find my, sorry, now I've shifted devices, it's quite difficult to find my way around. Sorry, yes. Yes, it is at page 983.
983. Thank you. Yes, I've got that.
So, I mean, the statement itself essentially relies upon documents, but it relies upon the payment instructions received by the bank. Now, my point is this: first of all, the bank doesn't need to rely upon these documents to make good its case. The bank's case, as I'm going to show you in due course, is based on the facility agreement and the other documents and the statement of account showing the sums that are due and the demand. So these are really documents that go to the defence advanced by NEOPHARMA, which is that the payment instructions were made in fraud of NEOPHARMA. So this is not something we needed to exhibit. And we put it in simply because it's said in the pleadings, albeit not in the evidence of NEOPHARMA, that these payment instructions were made in fraud of the bank, and that somehow the bank ought to have been aware there was a problem and not acted on the payment instructions.
Well, the documents attached to the statement attach a number of documents apparently signed by Mr. Shetty.
Yes, they do, which his expert has seen.
I say. All
yeah.
Right. And his expert commented on all of these documents?
Oh yeah. I mean, there's a slight glitch because the expert report itself was only served with the skeleton, But yes, we can look at that.
Well, I haven't seen the expert. I couldn't see the expert report in the evidence. Was that with the skeleton, was it?
Apparently, yes. I mean, I've seen it. I do object to
have you?
it coming in, but I mean, if your honour wants to look at it as a Banner essay, I mean, I'll leave Mr.
Can somebody help me? What page is it? Because I couldn't find it in the bundle.
Right, you'll find it at the very end, and it is at, again, excuse me. Well, first of all, let me show you Mr. Shaheen's witness statement, because
Yes.
this is, which refers to it. So this was back on the 5th of October. That is on page 594.
Yes.
So there's reference to the report. So the history is, well, I mean, I should really take your honour to all the documents, but the history is that the expert inspected the documents in June last year and apparently produced his report at that time.
Yeah.
And you see this referred to at page...
Paragraph 24, page 600.
Yeah, yeah, exactly, precisely so. So, exactly.
Yes.
So there's a reference, I mean, the history starts a little earlier. It's paragraph 20, Mr. Sheen's statement explains that there was an order from Justice Gross permitting inspection. Inspection took place. Mr. Al-Bar inspected. And then it says he's issued his report on the 24th of July. Now, weirdly, the report wasn't exhibited to this witness statement, as it obviously ought to have been. What we have instead is a summary from Mr. Shaheen. And if you scroll down, you see the disbursement requests, number 5.
Yes.
So he's seen them all.
Yes. All right.
And in fact, it's suggested that paragraph 27, it's pertinent to note that in the disbursement request, as mentioned in the table above, the expert has determined that Mr. Shetty's signature is forged and electronically copied and pasted. Well, I mean, that's odd because there's only one of them that he's signed anyway. There's 1 out of 8 has been signed by Mr. Shetty, so I don't quite know why it's referred to as a plural. But there it is. So the expert's seen that.
Can you help me with that? Because I saw a number of documents apparently signed by Mr. Shetty.
Oh, there are many. I'm going to say, I mean, we're doing this slightly the wrong way around, but I'm going to show your honour that he signed the sanction letter, the facility agreement, the 2 corporate guarantees, the personal guarantee, the account opening form, the first request for disbursement, an undertaking letter on behalf of NEOPHARMA, an undertaking letter on behalf of himself. At least those signatures. But of course, I mean, we principally rely upon, obviously, the personal guarantee. That's the one that really matters from the point of view of that claim against him.
There's no statement from Mr. Shetty, is there?
There's never any statement from Mr. Shetty, and there isn't in this case.
Right. Again, that strikes one as odd, but anyway.
Yeah, I mean, there are many odd things about this case. I mean, it's what I'm going to call the Shetty special, Your Honour. I mean, you know, the usual. Wasn't me, some other guy.
But you told me that because I was like you, I was curious because there's a reference in a lawyer's statement to an expert report, but I couldn't find the expert report. But it has now been provided.
Let me take you. Well, I mean, it is there, I believe. I'm being generous to Mr. Shaheen here, but I believe that we can. That should be it's at the very bottom of the bundle as appended to the skeleton. At least it was for me. Well, Mr. Shaheen can tell you where it is, I hope.
I don't think it was for the one that I saw.
Okay, well, I've seen it. Anyway, I've seen it, but I am objecting to its admissibility.
Well, Mr. Shaheen, is it before the court?
Your Lordship, 1389. 1389.
What?
1389.
1389. Thank you very much. Yes, that's right. Yeah. I mean, you know, I've got various observations on this, one of which is not a handwriting expert report at all. But yes, I mean, you can see that Mr. Al-Bar visited the bank's offices in June last year, and he was refers to some signatures that he provided from unspecified other documents, and then he carried out a series of inspections, as you can see, including the all the originals, lots of them.
Yes. Okay.
And you see, you know, there's a dearth of reasoning, and then there's purported evidence on things that aren't anything to do with handwriting. But you can see he's seen a lot, basically.
Yes.
So that's Mr. Albar. So he's had plenty of opportunity to look at this. And let me also show you how this was dealt with in terms of document production, because there was, before the application for immediate judgment was made in January last year, about a year ago, the bank made its initial document production round. And then we had a notice to produce by NEOPHARMA, which was served on the 16th of February, which is 1711. So, and that was support. I mean, that's just the application. But if you scroll down, you'll see the first witness statement of Mr. Antonios Dimitrakopoulos.
Yes.
And they're basically asking for specific production. And you scroll down to, oh, sorry, this is actually, no, sorry, this is a later statement. Let me get the order right. There was a notice to produce on the 16th of February. If you go to page 1710, you'll see that there was a schedule of documents requested, and number 11 was the request for all documents recording or evidencing sums drawn down pursuant to the facility agreement, all communications which drawdown requests were discussed, as well as documentation evidencing disbursements made. And they say, why is that relevant? Well, the first defendant pleads it was the victim of a substantial fraud perpetrated by its management, and pleads that drawdown requests were made in respect of false invoices, and the claimant should have been aware of such. So that was why they were asking for it. So then the bank then disclosed those documents on the 27th of March, 2023. And if you go to page 1755, you'll see the documents. I mean, there's 618 pages, so I won't take you through all of them. But there, essentially, I mean, that's the summary on top. But essentially, if you scroll down through the list, you'll see that in effect, all the documents, all the payment instructions, and all the supporting documents, there were various invoices and payment certificates and so on. They were all disclosed as per this list.
And when were they disclosed again, Ms. O'Sullivan? Can you help me? When were they disclosed?
Twice. This is the first occasion. So that was the 27th of March of 2023. Yeah. You'll find this in my skeleton proof.
Yes, thank you.
Anyway, so these were disclosed on the 27th, and then for some reason there was then an application for a formal order.
There's some background noise. Mr. Shaheen, could you go on a mute again, please? There's some background noise.
Okay.
Thank you.
So for some reason, although these were disclosed on the 27th of March, there was then a formal application for an order for the same documents by NEOPHARMA. I don't know why that happened. It doesn't matter. But that is what I'd like, if I could take you to page 1713, that was then supported by the witness statement of Mr. Dimitrakopoulos.
Right.
And what he's seeking here, he is specifically saying, we need these documents because we're running a fraud defense.
Yeah.
And if you scroll down, yeah. I mean, he refers at paragraph 9 to the amended defence and the plea of being fraud, and then he refers at paragraph 10 to the request to produce, and to request 11 of that request, and why it was relevant. And he says there the claimants refused to produce such documents. Now, that is true. There was an initial refusal, but then the bank changed its mind. Anyway, there was, for some reason, this application was then made, and in fact, Justice Gross ruled upon it in June last year. That is at page 120. Yeah. I mean, the order actually begins slightly earlier. The order begins on page 119. But the schedule, you see, he says it's hereby ordered that 1, the defendants identified as Redfern Schedule Request 11 shall be produced. And then there was also the order for the production of the originals to Dr. Shetty's lawyers. Yes, and if you carry on, yes, he explained in the schedule of reasons at 121 that the first defendant seeks a limited category of documents identified as Redfern Schedule Request 11, plainly relevant to material. Unless they've already been produced, there's no basis for not producing them. So they were produced and acknowledged by the first defendant. If you go to page 1553. No, that doesn't seem to be the right.
No.
No, that doesn't seem to be the right document. I'm having difficulties finding it. I'm so sorry. Sorry, I'm really struggling with technology here.
1753.
I'm very grateful. Sorry, struggling a bit with different devices here. Yeah, no, 1753. Yes. Yes, that's really helpful. Thank you. So yes, so if you scroll down, you see that on the 20th of June, there were links provided. The disbursement along with a report prepared by the signature expert, that's our handwriting expert, and the drawdown requests. And then if you scroll up, those were both acknowledged on the 20th of June. So my submission, it's pretty clear that the first defendants had this document for months. These are documents which don't go to the bank's case, they go to the first defendant's defence. They've had, if they wanted to make a case based on these documents that there was something about them that ought to have alerted the bank to a possibility of fraud by an employee, they've had ample opportunity to make good that case, but they haven't done so, inexplicably, in my submission. And so, I mean, again, I don't want to get my submissions out of order, but they seem to have assumed that when the bank made this application, it was relying on a statement made in some proceedings in India by counsel for Mr. Shetty in India, to the effect that he was a guarantor by reference to this guarantee. Now, we're not, and there was a great deal of material exhibited as SK 16 and 17, and we're not relying upon that anymore. We have much better evidence. But my learned friend seems to have assumed that that was the only basis on which immediate judgment was being sought. I'm not quite sure why he would think that, because that was just a question of evidence, and it didn't go to the case against NEOPHARMA anyway. So, you know, the bank's case is and has always been, as I've said, in a very plain vanilla case. Here is the facility agreement. Here's the statement of account, which, as I shall show Your Honour, is prima facie evidence of the debt. It hasn't been paid, demand's been made, and can we please have our money? I mean, that's our case. And this material has been, I mean, certainly Mr. Chauhan's second witness statement is late, but it's really been put in to make good a gap in the defendant's own evidence rather than the bank's evidence. So I'm not quite sure what the complaint's about, but it's certainly completely disingenuous for them to claim that they're disadvantaged or haven't had an opportunity to take instructions. And that's particularly so for Mr. Shetty. As we've seen, his experts actually inspected the documents.
Yes.
So in essence, I mean, as I say, I mean, at the end of the day, I don't need them. But if your logic may find it useful to see the kind of thing that was being presented to the bank as a request for payment, and that's why it's been put in. So, I mean, I think I submit that it is useful, but not essential. And I would ask you to admit it on the basis that there's no conceivable prejudice to either defendant.
All right. Well, do you want me to hear argument on that topic now, or should I defer it until you've completed your address?
I'm very much in your Honour's hands. I was going to make good my case without reference to documents anyway. But I mean, I'm very content if your Honour wants to make a ruling now.
Yes. All right. Well, counsel, let's deal with this admissibility question. Who would like to go first? Mr. Costello, Mr. Shaheen, who'd like to go first?
I'm okay either way. So if my learned friend wants to, Mr. Sheen wants to go first, he can go first.
All right.
D1 may go first.
I'm happy for Mr. Shane to go first.
All right, Mr. Shaheen, why do you object to the second statement of Mr. Chauhan?
It's a question to me, Your Lordship.
Yes.
It's submitted too late. All the documents on which Mr. Sujit Kumar Chauhan was relying on for the witness statement were all available with the claimant right from the beginning. There is no justification for the delayed submission. And if at all they believe that the case cannot stand without those documents produced along with the witness statement and the documents relied on in the witness statement, that shows the weakness of their argument for immediate judgment also. So only 8 days, just before the trial was supposed to start, that's the hearing date today, they cannot produce a document like this, Your Lordship. It should not be allowed. They first produced a witness.
Why not? Why not? How are you prejudiced? I could understand all that you've said if you are prejudiced by the late reception of the document, but I need to know why you're prejudiced.
I'm unable to respond to that witness statement itself. I need to take instructions from my clients who are abroad, and I didn't have time for that.
All right. Well, how would you? What instructions would you take?
I need to know what exactly. Sorry, Your Lordship,
Yes.
I couldn't hear.
No, you please. What information would you seek to put on in answer to the affidavit?
Because we need to answer that witness statement point by point, right, Your Lordship? So we need to take instructions from the client how to respond to that. So we didn't have time for it. We couldn't even review it thoroughly or get any instructions from the client. We are hard pressed with time. And in an immediate judgment application, where the evidence, everything should be on the place, on record, to show that the defendant has no prospective defense at all in the case. That's a basis for an immediate judgment application according to the RDC. If that is the case, why are they producing a witness statement in the 11th hour without giving anybody sufficient?
You haven't put on any evidence to support the proposition that there was a fraud perpetrated at the time the funds were drawn down, have you?
All that we
There are
could do.
allegations made in pleading by both defendants, but there's no evidence of that, is there?
All that we could do is, Your Lordship, when it is alleged that it bears my signature, first of all, I denied that it is not my signature by Dr. Shetty, the first defense statement itself. Second thing is, Your Lordship, the burden of proof is always heavily on the claimant when someone denies the signature. They produced an expert report. Then we requested the Honorable Court permission to...
I'm not concerned at the moment with the signature. I'm concerned with the separate argument that there was a fraud perpetrated at the time of drawdown. So the proposition is that there were employees of the first defendant who were fraudulently misappropriating the funds, and the proposition, I think, is that the bank should have been aware of that. Now, that's been pleaded, but there is no evidence of it, is there, that I can see?
The only thing we can do, first of all, to establish whether it is a real signature or a forged signature in order to come to a fraud conclusion. Second thing is, if we have to approach the Dubai police...
Mr. Shane, you keep on talking about signatures. I'm not presently talking about Mr. Shetty's signature. I don't want to hear about that. What I'm asking you about is the separate allegation that there were senior employees of the first defendant, NEOPHARMA, who fraudulently gave instructions to the bank to pay money to an account in Abu Dhabi, which they controlled, with the result that the funds were misappropriated and never got to NEOPHARMA. Now, I've seen that in the pleading, but I haven't seen any evidence of it. So am I right in thinking that there is absolutely no evidence of that?
The fraud is the result of the forged signature, Your Lordship. If I may be allowed to explain, I can clarify that. Right. Only way to prove fraud is by filing a criminal complaint. And if we have to file a criminal complaint, the Dubai police insists on having original documents. Without the original documents, it's
I'm sorry, I don't understand. What did you say? The only way you can prove fraud is by a criminal complaint?
I don't get it, Your Lordship. No, if the only way to...
Did you say fraud? Well, these are civil proceedings, and if you want to defend them on the basis of fraud, you have to prove them in this court.
I can only allege at this moment, unless I have in my hand the original documents and I'm allowed to file a criminal complaint. Because Dubai police will not accept a criminal complaint without the original documents. There is no way. And criminal case has to be filed against an individual. I don't know who exactly did it. There are plenty of cases going on globally in the various places about these incidents.
Well, the short answer is you have no evidence before this court to support the allegation that there was fraudulent misappropriation at the time the funds were drawn down. That's right, isn't it?
I only have the expert report at the moment.
Well, the expert report goes to Mr. Shetty's signature.
No, Your Lordship. It doesn't confirm at all. It shows serious doubts about the signature, and all the signatures are copy-pasted. The signature is fraudulently affixed. All this is confirmed in the expert report, which I produced along with the skeleton.
That's Mr. Shetty's signature.
Yes, Your Lordship.
Yes, all right.
It's not his signature. It's confirmed by the expert report now.
All right. Well, what would you do if you got the second statement from Mr. Chauhan 2 months ago? What would you have done?
We would have responded it point by point and clarified our position, Your Lordship.
But how? How? Mr. Shetty, your client, says that he didn't sign any of the documents. How could you respond?
We have submitted the expert report to show that it is not a signature. Signatures have been copy-pasted. It's not matching.
Well, yes, but so we've got the expert report. What I want to know is what else would you have done? What else could you have done?
Only thing, the additional step that I can do is filing a criminal case, for which I need the original document. Without the original document, the police is not accepting a criminal case complaint.
All right. Well, then you couldn't have filed a criminal case because you don't have the original documents. So what else could you have done?
There's nothing more. We can only respond to that and clarify the position to the Honourable Court.
But how would you clarify it? Mr. Shetty says he knew nothing about this. I don't understand how you would clarify it. Your case is that he didn't know anything about it. So what could he do?
Lordship, the cases are, as I explained, this is not one case. There are plenty of cases globally in different places in US, UK, India.
Mr. Shaheen, I'm dealing with one case, and I'm dealing with the case on the basis of the evidence that is before the court in this case.
But
and
for the client,
evidence in relation to other claims, you've got to put the evidence before the court.
For the client, sir, for Dr. Shetty, it's one case which is going around in various places, and without a proper coordination between the lawyers, I cannot submit something before this honourable court. I need time to do that.
Well, I still don't understand how time would help you. Can you just tell me how time would help?
So this is only after a discussion, or maybe by a conference call. If I'm unable to travel, at least by that I need to coordinate with the instructions of the client, given to the other lawyers also. Then I have to coordinate, ensure that my reply is not inconsistent with what has been stated before the other courts. In this case also, they had picked and chosen one document submitted before an Indian court for starting with the immediate application, stating that he is considered as a guarantor. Then they withdrew the very basis of the application. This is what happens, Your Lordship. So I have to be extremely cautious.
I'm not concerned about all of that. What I'm concerned about is your case in answer to the bank's case. Now, why hasn't Dr. Shetty put on a witness statement? If he says he didn't sign them, why hasn't he put on a witness statement saying he didn't sign them?
If I have denied something, Your Lordship, where is the burden of proof? The burden of proof is heavily on the bank. I'm not supposed to prove the bank's case. We are lawyers, officers of the court, helping the court to arrive at the right conclusion. So we are here examining the veracity of the evidence produced. That's all we can do. Rest is up to the bank to prove their case, Your Lordship, not me.
But if you allege that something has been forged, ordinarily the person whose signature has been forged would go on evidence and deny that that is their signature. Now that hasn't happened, and is there any reason why that hasn't happened, Mr. Shaheen?
The signature has been denied, Your Lordship, and it can only be proven in a trial.
Denied in a pleading. It hasn't been denied in evidence. And the only evidence I've seen is evidence from lawyers. There's nobody on behalf of any defendant has given direct evidence of anything. Lawyers are saying what their instructions are.
The statement of defense clearly says that. The expert report produced clearly points at that. It can only be decided in a trial. And the court is not supposed to.
Mr. Shaheen, a statement of defense is nothing more than an allegation. It's not evidence of anything.
I understand.
You're providing a witness statement saying this is in the defense is of no evidentiary value at all.
How can negative be proved, Your Lordship? I'm denying something. I cannot be asked to bring evidence for a denial.
Well, Mr. Shenny is the man who is supposed to have signed these documents. It would be simple for him to say he didn't sign them, but he hasn't, has he?
And when there is a denial, absolute denial, it is for the other party to establish that the document they are relying on is genuine. And for that, I have taken that extra step, hiring an expert, inspecting the documents. I have produced the document also before your Lordship.
There's no statement from the expert, is there? Is there a witness statement from the expert?
I haven't got an opportunity. They are jumping into an immediate judgment application when a proper trial is required. And the Honorable Court is not supposed to conduct an immediate trial event.
Mr. Shaheen, just listen. You, according to your witness statement, you got the expert report in July of last year, didn't you?
I see, Your Lordship, the date was not agreed. There was a case management conference. The inspection happened. And before even the expert could prepare the report, they came up with an immediate judgment application all of a sudden from the blue. And
Mr. Shaheen, just listen to my question, please, and answer it. Did you or did you not say in your witness statement that you received an expert report on the 24th of July last year?
Yes, Your Lordship.
All right, well, that's much, if you just listen to my questions and answer them, we'll get on a lot quicker. Now, if you've had the statement since July of last year, why hasn't the expert put on a witness statement saying, this is my report and I hold this opinion?
There was no opportunity given. It was immediately the immediate judgment application. Before even
why didn't you put that statement on in answer to the immediate judgment application?
We have stated that, Your Lordship, we need time. This is not a fit case for immediate judgment. If an immediate judgment can be given in this case, no bank claim requires a trial afterwards. Every bank claim has to be decided.
You've had 6 months to produce a witness statement from Mr. Al-Bahar. I still don't. Why haven't you produced a witness statement from the expert?
There is no trial, Your Lordship. In an immediate judgment application comes, it takes into a different tangent altogether. The trial is completely vitiated. There's no trial here. It's their immediate judgment application.
I don't understand any of that, Mr. Shaheen, but I think we're going around in circles.
See,
I still don't understand how you're prejudiced. You say you're prejudiced because you need to take instructions in relation to the drawdown, do you?
Your Lordship, when there is a case management conference, dates are agreed. Everybody is supposed to honor those dates. Here, there is a consent order when the inspection has to happen. There is no date fixed for submission of the expert report. Before that comes an immediate judgment application from the blue, completely disturbing the whole timetable agreed in the consent order. And then there was no opportunity. It was only the immediate judgment application which was under consideration. And it's a well-established principle, Your Lordship. The court cannot even conduct a mini trial in an immediate judgment application.
I'm well aware of that principle, Mr. Shaheen, but I'm still looking for any evidence that would sustain your defence. And
denial is there.
One witness who would sustain your defence.
There is an absolute denial of signature.
That's not evidence. You understand the difference between a pleading and evidence?
Yes, I do understand, Your Lordship, but it can only be done in a trial. Immediate judgment application, you can only submit a different statement. There is no time given for anything else.
Well, that's not right. That's just not right, Mr. Shaheen. There's plenty of time for you to put on evidence in answer to the application, and you haven't. But anyway, I think we're going around in circles. I'll hear from the first defendant now. Mr. Shaheen, is there anything else you'd like to say on the admissibility of the Chauhan statement?
I didn't get the question, Your Lordship.
Is there anything else you would like to say in relation to the admissibility of the second statement of Mr. Chauhan?
I need time to respond. I need time to take instructions. I need time to coordinate with the lawyers handling various cases across the globe to submit a proper reply to that.
All right. Thank you. Mr. Koshtel.
Yes, my lord. In answering the question, may I begin first with the application for immediate judgment? I know my learned friend, Ms. O'Sullivan's already alluded to it, but the reason why I start there is because, and you can find the application at page 132 of the bundle.
Yes.
The reason for the filing of the present application is set out, and as Mr. Sullivan said, there was reliance placed on an aversion within the, sorry, an admission, purported admission in the High Court of Karnataka proceedings. After which we hear of the brief facts in the case, and then moving on to page 142 of the bundle, the grounds for the application are set out. And again, it's focused entirely on the alleged admission in the Indian proceedings, if I may call it that. And that continues throughout until paragraph 27, where the interim relief is set out. Now, the reason why I start there is because the starting point to the claimant's application has always been reliant solely, I say, on the alleged admission before the Indian court proceedings.
Well, I don't understand that submission, Mr. Costello, because when you look at the document, go to paragraph 26, there's a clear allegation that the documents were all signed. There's
yes, I understand that.
The reference statement in the High Court of Karnataka.
Yep.
But the fundamental allegation is that the documents are legitimate.
Absolutely.
And the admission made is relied upon as evidence of that.
Well,
I don't understand it. I don't understand how you can say that the sole and entire basis of the application was the statements made in the Indian court.
The reason why I say
that
that
doesn't match the document.
I'm sorry for interrupting you a number of times. I'm sorry. There's a bit of a delay, I think.
Yes.
But just to answer my lord's point, the way the claimant presented its application at that stage was that the signatures which were alleged to, which are said to be forged, cannot. The claimant says, well, that defense goes out of the window because it made Dr. Shetty made an admission in the High Court proceedings in India that he was a guarantor. So it's not as simple as there is evidence of a forgery. The application for immediate judgment has been, forget everything you hear in the DIFC court's proceedings, because what you have before you from the Indian court proceedings is enough to grant immediate judgment against both defendants. That's the way the application has been presented, and that's the way the claimant sought to rely upon the Indian court proceedings within the context of the DIFC court proceedings. That being the case, the responses received by from the first defendant and the second defendant, and I'll focus mainly on the first defendant as I represent them, was to deal with this point. I accept that Mr. Chowan provided his a witness statement exhibiting a number of documents, as I'm sure my own friend is going to rely upon, but that can only be read in line with the way the application was presented, because those documents that were exhibited by Mr. Chowan initially were documents that were already available. Nothing really surprising. There's nothing surprising about them. They were
the documents upon which the claim is based.
Yeah,
they were
that's
the
right.
essential documents giving rise to the claim.
Yes,
they
yes,
were the agreements and the guarantees.
And that's my point. They are the documents.
Nothing surprising in them. I agree. There's nothing surprising in them. They were the bedrock of the claim.
Yes, but the point is that was not the way upon which the immediate judgment application was presented, nor was immediate judgment.
Why do you say that? Why do you say that it wasn't the way it was presented? Because the documents were all attached to the statement. They were relied upon.
Correct, but it was the alleged admission before the High Court proceedings in India that the claimant said is enough for the judge, for the DIFC courts to look at the other documents in the DIFC courts proceedings and to conclude that this is his signature. That's the way the claimant presented his application. Now, there was
a handwriting expert,
which came at reply stage. That came at reply stage. Yes. If you would like me to take you to it, I can, but I hope you would take it from me. But that came at reply stage. Now, what then happened is that as my own friend says, there was correspondence from the claimant to indicate that there was not going to be any further reliance placed upon the evidence from the Indian court proceedings. Then came the second witness statement of Mr. Chow, and in fact, there's a third witness statement as well. But in relation to the second witness statement, I have seen the expert report from Mr. Al-Bar, and I have seen that he has looked at the application for the loan. What I can't see is whether he has looked at the power of attorney. I'll say it, the purported power of attorney, which you will find right at the end of exhibit SKC 2.1, which is at page 1010 of the bundle. So this is supposedly a power of attorney. There are comments that need to be made here anyway, but we don't accept this as a valid power of attorney. It hasn't been notarized in the UAE.
When did you get this? When was this relied upon in evidence, Koshto?
As part of when it was relied upon, I honestly don't know, except that I don't disagree with what my learned friend says, that it was probably submitted. I can't remember when it was in 2023, but anyway, it was either June or March. I don't take issue with that. The issue that we would take is, for the purposes of this immediate judgment application, it was exhibited to the second witness statement, which came after the close of evidence, and therefore there hasn't been a chance, certainly not from the first defendant, to respond to any of the evidence that has been submitted. But secondly, it's not clear whether this document
is this document considered by Mr. Al-Bar?
This is the point. I can't see. It's not that clear to me. Can we, if we look at Mr. Al-Bar's report 1389? That's the beginning. 1392 is the list of documents that have been inspected. So we've got the original facility.
It's number 7.
Yeah, so I was going to come on to this. As I said, I've seen that the original bank account opening for the application for the loan was considered. What I couldn't quite figure out is whether that included the power of attorney. Now, it may have, but I don't know. And I suggest it's not that clear. He may have, he may not have, but I think that needs to be clarified.
Well, do you rely on Mr. Al-Bar's report?
Well, certainly, because the first defendant's defense, part of it certainly is that there was a fraud, and in addition to that, that Dr. Shetty did not sign various documents. Obviously, we are effectively, to use an awful expression, piggybacking off the fourth defendant's case, but that's where we're at.
Well, all right. Well,
Now,
are you able to shed any light on why Mr. Al-Bar hasn't provided a witness statement?
Well,
expressing his opinion.
Yeah, I should say the first defendant hasn't instructed Mr. Al-Bar. All I can say is, looking at the report, it's clearly well, I know my learned friend disagrees, but anyway, for the purposes of this conversation, it is clearly an expert report, at least so it says. And if we look at the end of the report, I'll give you a page number. Page 1406. This is the declaration. So he said he calls himself an expert. This looks like an expert's declaration. He also refers to part 31 of the rules at page 1407. And so, at the very least, there is a statement of truth with the expert's declaration of an expert's report, which is evidence that would be considered at trial. Now, does there need to be a witness statement or not?
It would be considered at trial if Mr. Al-Bar came and testified.
Sure, but in my respectful submission, it's reasonably expected that there will be a witness statement. Now, whether it should come at the immediate judgment application or not, in my submission, nothing is really going to turn on that, because it's reasonably expected that an expert who's given a statement of truth, a report with a statement of truth, is likely to give evidence. Anyway, at the very least, my learned friend, for the fourth defendant should be able to confirm whether the intention is to call Mr. Albar as a witness. And in doing so, there will be a witness statement that will exhibit this report. So that's the most I can say on this report. At the very least, it's evidence that is before you. Now, going back to the first question on prejudice, the difficulty is, I say, with my learned friend's the application made by the claimant, is that the way that it was made initially is no longer relied upon. That does mean that the entire basis of the application is either considered to be flawed, or if it requires response, then it requires response in total and not just limited to the second witness statement. But if I'm wrong about that, then at the very least, for the second witness statement of Mr. Chowan, there would need to be evidence in response. The other point I should say.
Sorry, why do you say that? Why do you say that if a party withdraws reliance upon part of the evidence adduced in support of an immediate judgment application, the application is flawed? I don't understand that.
Because a party that relies upon evidence, as in presents the evidence in the case, and then says, the reason why this is all accurate is because of an admission in the Indian proceedings, is that party's way of choosing how to present that application. The necessary response in relation to that application is determined by the way it's presented. So when the claimant says, got
any authority for that proposition, Mr. Costello? Because on the face of it, it doesn't strike me as being right.
No.
Is there any authority to support that?
My lord, I'm making this submission not based on any case law, but on the basis of just frankly what you see before you. If a party sees the application, has the evidence in the case, and has attached to it and submissions saying exactly how the immediate judgment application ought to be granted, then the party that's responding is entitled to treat that application as made on the way that it's made on the papers and respond accordingly. And that's the way I put that submission.
All right. Well, tell me about prejudice. What would you have done if you'd had Mr. Chauhan's statement 2 months ago?
So one of the issues that Mr. Chauhan speaks of, one of them is about the signatories. So we've already looked at the power of attorney, and within the power of attorney, I'm just trying to find a page number again. If you just bear with me. Yeah, 1010. Authorities given to Mr. Suresh Kumar.
Yes.
By Dr. Shetty. My learned friend's case is that drawdown requests were made, I think, at least on 8 occasions. She is helpful. Ms. O'Sullivan has helpfully listed those at paragraph 18 of her skeleton argument. Yes. 7 of those were by Mr. Suresh Kumar. Now, if there is a question as to the authenticity of this alleged power of attorney, that needs to be responded to. If there is any point that needs to be taken and responded to in relation to the authority given to Mr. Suresh Kumar, again, that needs to be responded to. So if we had this evidence before, then the court would have had evidence dealing with this point. Now, the difficulty is...
What sort of evidence? What sort of evidence?
Well, a witness statement, probably.
Well, from whom?
I don't know. I'd have to ask my client, to be honest.
Well, you haven't put on any witness statements at all in support of the allegation that there was a fraudulent drawdown of funds, have you?
No, we haven't. In relation to this application, in the context of this application, we say that because of the way the application was presented, and I don't want to repeat myself again, no evidence was required. The first defendant was meeting a submission that admissions in the High Court proceedings was enough to resolve the entire case against the first defendant. Now, if the application was presented on the basis that if you look at all the evidence in this case, that leads you to the putting aside, in fact, let's just ignore the Indian court proceedings. If the claimant said, look at the evidence in this case, and look at the expert report, this is why we're right, then that would have been a different story. I know my learned friend's going to say, well, there's never been any production in this case, etc. And I can't get around that. There hasn't been any documents produced by the first defendant. Now, whether that would have prompted any documents to be relied upon and submitted as part of the immediate judgment application, albeit late in the proceedings, and as unattractive as that might seem, it still would be in accordance with the principles of due process for that evidence to be placed before the court, especially when dealing with an application such as this, which is to end the entire proceedings altogether.
Do you have anything else to say about Mr. Chauhan's second statement?
No, sorry, there was one more. There was one more. There is a certificate, an audit report submitted, dated the 20th of March 2018, page 1011. And this is an audit letter, if I'm not mistaken, to the manager of the claimant company. Now, the claimant relies upon this to demonstrate that the drawdowns were not only known by the first defendant, but were actively pursued in the sense that they support her submission of affirmation. Now, as the defense is that, first of all, Dr. Shetty's signature has been forged. Secondly, that it seems to have been misused, i.e. copy-paste, etc. There would need to be evidence from NEOPHARMA to explain why the audit says what it does, or why this letter says what it does, what were the circumstances, and when the payments were stopped, why were the payments stopped? Why was it that drawdowns seemingly were, on the face of it, made, requested, monies were transferred, audit letter says what it says? There are so many questions that need to be answered. Now, this can only be done by taking instructions and submitting a witness statement. Again, from whom exactly, I can't say. Sorry.
How long would that take?
I don't know, because we haven't been able to get that far, but I would say a reasonable amount of time ought to be anywhere between 14 days and 28 days.
Okay. Thank you.
That was the second
Anything
point, and that
else?
was the final point. Sorry, I spoke over you. I was just saying that was my second point and the final point on that Mr. Chauhan's statement. So I have nothing further to say.
Thank you. Now, Mr. Shaheen, before I go to Ms. Sullivan, just how long would you need if you had been given the documents earlier? How long would you have needed the second statement? How long would you have needed to take instructions and respond to it? Can't hear you. You're on mute, I think.
Sorry, Your Lordship. Maybe 2 weeks' time?
2 weeks. All right. Okay. Thank you. Ms. O'Sullivan.
My lord, if you're giving serious consideration to an adjournment here, I will withdraw my reliance on this statement. We don't need it. It goes to their defence. Now, the legal burden of proof obviously is on the bank, but this goes to the defence as the defendants. The burden is on them to show at least some evidence that there was a fraud at NEOPHARMA and or that Mr. Shetty's signature has been forged. Now, I mean, the question is why haven't they put in the evidence? I mean, that comes down to the basis on which the application was made. The application was made on the basis that here are the banking documents, here's evidence from Mr. Chauhan that the money is due and hasn't been repaid, and we want to be paid. I mean, if they want to say there's some defence, they need to put the work in and produce the evidence. And if for some reason they've chosen not to, I'm afraid that's their own self-induced error. I mean, the Karnataka evidence was only ever a marginal part of the evidence. It doesn't relate to NEOPHARMA at all anyway, it only relates to Dr. Shetty. NEOPHARMA, I mean, it's irrelevant. The bank's case against NEOPHARMA, it's irrelevant whether or not the signature was genuine or not, because it's not alleged that the bank knew or ought to have known that it wasn't genuine. I mean, they must make the running on these points. And the absence of evidence is, well, I mean, if there were a fraud, it's inexplicable. I mean, one has to be very doubtful about the quality of the case that's being advanced, but there isn't a statement of truth in NEOPHARMA's defence. very, very serious allegations been made against individuals who are not here to tell their side of the story. And your lordship doesn't know whether this is just an outrageous slander on people who aren't here, or whether there's any truth in it at all. I mean, you've just not been given any basis for understanding any of that. So, but I would urge your Honour to admit the statement, because they've had the documents for, well,
Yeah.
they've had the documents
But
but yes.
I think there's a difference between having documents and knowing that the documents are going to be relied upon in order to sustain for immediate judgment.
Well, if I'm going to be put to that, I would rather abandon reliance on the statement and go ahead without it, because it's really not my problem, it's their problem.
All right. Well, I think my position is, Ms. O'Sullivan, as you anticipated, I think out of an abundance of caution, if you do wish to rely on the statement, I think I would need to give the defendants an opportunity to respond to it.
Right.
And I don't
I think that would be
that
very
long enough.
It's taken 6 months to get this on after the application was made in July. And so I'm going to rely upon that.
We could get it back. They've been talking about, nobody's asked for more than 28 days. So we could bring it back on shortly after 28 days.
My lord, I don't want to bring it back on. My submission is, I'm happy to proceed without the statement.
Right. All right. Well, then then if that's your choice, then I won't admit the statement.
Thank you very much. In that case,
Right.
I will simply proceed to my case without reference to the statement.
Yes, thank you.
So, can I begin then, Your Honour, with the sanction letter on page 157 of the bundle?
Yes.
The first in the series of documents I need to show you, Your Honour. So this is on the 12th of September 2017, and it's advising of the bank's decision that it will grant the facility. And obviously there's an existing banking relationship, and NEOPHARMA wants a further term loan to fund the construction of I think, expansion to one of its pharmaceutical production plants. And if you scroll down to page 158, you will see that payment was to be made, repayment was to be made in quarterly instalments over a 5-year period.
Yes.
And if you look under disbursement towards the bottom of the page, it says that disbursement of loan which we made directly to the supplier contractor on submission of quotation work certificate. However, disbursement may be reimbursed to the company in case of payment, advance payment, and so on. So in other words, it can be paid directly to the contractor, third-party contractor, or if NEOPHARMA says, well, this is the money we've spent, then it can request a reimbursement.
Yeah.
Now, if you go down to clause 22 of this document, there's some other, on the next page, there's something headed other terms and conditions. And clause 22 of this says that the release of the disbursement of facilities will be subject to compliance with pre-disbursement terms and conditions, undertaking to create possessory pledge, plant and machinery, medical equipments within 3 months of the envisaged date of completion. And it asks at the bottom, please return a copy of this duly signed by authorised signatory. And therefore, and then it comes back, in effect, there's an implied representation here. This is our authorised signatory, and it's Mr. Shetty on every occasion, on behalf of NEOPHARMA, on behalf of the 2 corporate guarantors, and on his own behalf, as the person giving the PG, and that's Abu Dhabi on the 14th of September. Now, now can we look at the facility agreement, which was 2 days later? That's at page 163. It's actually the next page. And this is, as you can see, I mean, it's a standard banking document in a very familiar form. It has been stamped and initialed on behalf of NEOPHARMA on every page. I don't know whose initial that is, but it's been initialed on behalf of NEOPHARMA with the stamp. Now, if you go to clause 2 on page 174, that recites clause 2 that recites the purpose of the loan. Well, it recites that it makes available the facility. It's the borrower's obligation to make sure the facility is used for the purpose for which it's sanctioned. And on 3.2, the lender is not bound to monitor or verify the application of any amount borrowed. And then at clause 4, we have conditions precedent to the release of the funds, which we will see in due course. That includes the delivery of the duly executed corporate guarantees and the personal guarantee of Mr. Shetty. And again, clause 4.1 envisages that the bank may disburse the loan either directly to the contractor or by way of reimbursement of sums to NEOPHARMA. If you scroll down to the next page, it's actually page 176, clause 5, that says that the borrower may utilise the facility by delivery to the lender of a duly completed utilisation request. I'll show you the template in a moment. But you'll note there that the language is not mandatory, because that's one of the points taken by NEOPHARMA, that somehow if there isn't compliance with the precise template, then that somehow means that the money advance isn't recoverable. Now, on page 178, clause 6 sets out the repayment dates. And if you want to go there, if your lordships note, it's the repayment dates are actually in Schedule 1 at page 226. We don't need to go there at the moment. They're summarised in my skeleton. But it was essentially unequal quarterly payments over 5 years. Clause 8, which is on page 181. Clause 8.1 deals with contractual interest, which was payable at margin over 3-month USD LIBOR, subject to minimum of 4.5%. That was contractually varied at a later date, which we may come to in due course. And then by 8.2, sorry, there's 8.3, there's penal interest following a default. That's an extra 2% over and above the contractual sum. And now if you go then to page 206, you get to the events of default clause, which as usual is in clause 20. And the one we rely upon is clause 20.1. Non-payment, the obligors do not pay on the due date any amount payable pursuant to a finance document. Now, there are various other breaches of the facility, which we could rely upon, but the purposes of this immediate judgment, this is the one we rely upon. And if you go down to page 209, you see clause 2017, that's the acceleration clause. Again, as it often appears at 2017 for some reason, but that basically, once there's been an event of default, the bank is entitled to accelerate the full amount, plus a principal and interest, and demand immediate repayment. And then if you go to page 220, by clause 26.1, in any litigation or arbitration proceedings arising out of in connection with a finance document, the entries made in the accounts maintained by the lender are prima facie evidence of the matters to which they relate. And then if you go down to page 222, you'll see the governing law and jurisdiction clause, which are the governing law is a DIFC law, and the jurisdiction clause is at 32.1. Now, if we go to page 225, this is Schedule 2, and which sets out the conditions precedent. And various security documents are intended to be provided. They want duly executed copies of the guarantees, sanction letter. There's a promissory note as well, and other documents. I'll show you those in a moment. So those are all conditions precedent to the release of the facility. Without the provision of these documents, including the PG, the bank wouldn't have released the money. And then if you go to page 227, that's the standard form of utilisation request. And then at 234, you'll see the signature of Mr. Shetty. And then NEOPHARMA also gave a letter of undertaking, which you see at page 671. That was signed by Mr. Shetty. On the second page. And then if you go back to 235, there was a corporate guarantee from the second defendant, that's NMC Healthcare, which is in administration in the ADGM. And that was signed by Mr. Shetty on page 236. A bit lower than that, but it's page, sorry.
236, yeah.
Yeah, 236. Yeah, there's actually, yes, that's right. And then there's a second. Yeah.
I can't see Mr. Shetty's signature on 236.
Sorry, no, it's 245. I beg your pardon.
Yeah.
It's 246.
Yes, thank you.
Yeah, and then if you scroll down to the next page, it's a second corporate guarantee given by the third defendant, that's New Medical Center, LLC, and that's signed by him at 258. And then, as I said, that we saw one of the CPs was a promissory note signed from NEOPHARMA, which is at page 259. Again, signed by Mr. Shetty. So on his case, all these documents have been faked, or rather forged. So, but as you can see, there's a comprehensive suite of formal banking documents, all signed by Mr. Shetty. And the bank was also given his passport and visa details at the time. That's 673. There he is, and his his passport. And then of course we get to the PG, the personal guarantee, which is at page 260.
What page is that? 360?
260.
260, thank you.
And if you scroll down to clause 1.1, it's guaranteed liabilities. It means all amounts owed by the borrower to the lender under the facility agreement, including principal, interest, default interest, fees, commissions, or any other amounts arising under or in connection with the facility. And that is what he's guaranteeing that he will pay. And again, this, if you go to clause 20 on page 273, you'll see that this clause is governed by, this PG is governed by DIFC law, subject to the jurisdiction of this court, and it's signed at 275. And in addition to this, he gives a personal undertaking to make funds available for the repayment of the facility, and that's on 276. So there's a substantial number of documents which bear the signature of Mr. Shetty. Now, I don't need to show you the payment instructions to make this good. NEOPHARMA drew down the loan in 8 separate instalments between the 24th of September and the 3rd of May 2018. Total amounts about 99 million dirhams. But what I'm going to rely upon is the statement of account at page 548. And you can, this is a complete statement of all the payments made to and by NEOPHARMA under the facility agreement. So NEOPHARMA did service this loan for some years, which is a complete answer to any suggestion that it might have been authorised. You can see the various debit entries for the loan disbursements. You can see the first one on the 27th of September, and the credit entries for interest payments. And if you go down to 551, you'll see that the final payment was made on the 3rd of May 2020, and that was the interest payment due for February 2020.
So what page was that again, Ms. O'Sullivan?
Sorry, 551, it's the end of this account statement.
Thank you. Thank you.
And so the final payment was the 3rd of May, but it says interest payment Feb 2020. So that was in respect of the interest payment due in February 2020. Now, this statement of account has not been challenged by either of the defendants, and it's been verified by Mr. Chowhan on behalf of the bank in his first witness statement. And Your Honour will recall that under the facility agreement, this is prima facie evidence of the sums due.
Yes.
Now, at the time when it ceased to make repayments, this is the time at which the fraud at the NMC Health Group was becoming public. This was just before the English parent company went into administration. The English parent company went into administration in England, which sort of triggered the whole collapse of the group. That was in about beginning of April 2020. So then, on the 27th of July 2020, the bank exercised its right to accelerate the loan, and that's at 529. So that's addressed. So that's actually the one that's addressed to one of the debtors, but there's a full suite. Yes, the 528. No, I'm sorry, beg your pardon. One of these many documents is addressed to the first. Yes, here we are. It's on 538. That's the demand addressed to the first defendant, NEOPHARMA. And then if you go to 540, you'll see that demand was also sent to Mr. Shetty on the same day. And as Mr. Chowhan disposes in his first statement, neither of them has made any payment in response to the demand. And the loan was classified as a non-performing asset on the 21st of September 2020. And that, in my submission, is sufficient to establish the bank's right to judgment, subject to any defences of which there's any evidence, of which there is none. There's a little bit of procedural history, but I think I don't need to take your honour to that. You've seen the history of the disclosure of the banking documents. So just dealing briefly with the points that have been pleaded by the defendants in their defence. I mean, as you know, NEOPHARMA's defence is that it was a victim of a fraud by its own employees who presented false invoices and then diverted the funds into their own pockets. And there's, if you go to page 57, that's been set up in paragraph 9.2, and two individuals who conveniently happen to be the individuals who signed the requests, or rather didn't sign the requests, but were corresponding in relation to the requests, Mr. Matthew and Mr. Rajiv, are said to have been involved in a fraud. Very serious allegation, with no supporting evidence whatsoever. I mean, there's a reference there to the first defendant's investigations. Well, we haven't seen any evidence of those investigations. One would expect there to have been at least internal investigations, possibly a report to police, some possibly civil proceedings, nothing at all. And this defence has not been signed with a statement of truth, as required by the rules of court. So no one has been prepared to vouch for the truth of this fraud case. And as I've said, you don't know whether there's anything in it or whether it's just an outrageous slander on people who don't happen to be here to defend their good names. And serious allegations like this do require evidentiary support. And as I said, even if there were a fraud, I'm sorry, there is some interference. I don't know if it's just me who can hear it.
No, there's some building work going on next door.
Ah, thank you.
I'm afraid.
I shall continue. So
I'll go on to mute for the moment. Just bear with me. Just where are we? Hang on.
Thank you. So even if there has been a fraud at NEOPHARMA, that isn't an answer to the bank's claim for repayment. I mean, that's just NEOPHARMA's problem, I'm afraid, and they need to take their remedies against the people who've defrauded it. But NEOPHARMA says, well, the bank ought to have been aware of the fraud and refused to honour its payment instructions. If you see that, if you look at page 57, you'll see that at 9.3, it says, the purported works, which are the subject of the request in this instance, could never have formed a proper basis for the drawdown requests, in that there were no maintenance or upgrade works taking place or planned at the time of the drawdown, as was either known to the claimant or easily discoverable by the claimant. Well, that's something that really cries out for particulars and evidence. I mean, were there no maintenance works taking place? What was this known to the claimant? And if so, how? Or was it easily discoverable? In which case, why and how? Now, then if we go down to paragraph 15 of the request, of the defence, which is on page 59, a little bit more detail, says the drawdown requests for extremely large sums. I mean, the claimant should have, but it appears did not, take any steps to verify that the requests are genuine requests and the requests were in respect of genuine invoices and for sums genuinely expended, and that in all the circumstances the requests were properly authorised by the first defendant. Well, I don't need to go to the documents to tell your lordship that all the requests were sums within the amount of the sanctioned facility, as you'd expect. So that whatever extremely large means. I mean, as far as a bank is concerned, $30 million isn't perhaps an extremely large amount of money, but there you are. But the pleading there that the bank was under a duty to take steps to verify that requests are genuine is a misunderstanding of the law. Now, this hasn't been pleaded or explored at all by my learned friend, but I mean, as I said, this appears to be an attempt to rely on what we call in English law the quince care duty, and which, as I said, has been recently considered by the Supreme Court in Barclays Bank and Philip. And I wasn't proposing to take your lordship to anything beyond the head note of that case, which is at 1137. Because this establishes at the highest level of the English courts, and therefore persuasive authority, there's no obligation on a bank to take steps to verify payment instructions which are clear and given to it by the customer or the customer's authorization. The duty will only arise if there are reasonable grounds to believe that the instructions are fraudulent. And in fact, it's a breach of mandate for the bank to delay complying with its customer's instructions in the absence of red flags. So you can see that from the head note. The starting point is a basic duty under a bank under its contract with the customer as a current account and credit to make payments from the account in compliance with the instructions. And the duty is strict as to carry out the instruction promptly without concerning itself with the wisdom or risks of its customers' payment decisions. I should say this case is concerned with an authorised push payment fraud where someone gets at the owner and pretends to them that they're helping out an inquiry, and then they make the instruction to the bank, and the bank says, "Are you sure?" And the customer says yes, and so the bank makes the payment, and of course it turns out there was a crook. But that's a slightly different fact scenario. But I mean, so it says the bank has a duty not to execute a payment instruction given by an agent of its customer without making inquiries if it had reasonable grounds for believing that the agent was attempting to defraud the customer. That's the quince care duty. That duty does not apply where the customer unequivocally authorised and instructed the bank to make a payment. Provided the instruction was clear and given by the customer personally or by an agent acting with apparent authority, its duty was to execute the instruction. And any refusal or a failure to do so would prima facie be a breach of duty by the bank. And it's the fact that the customer's payment instruction was induced by fraud did not invalidate the instruction or give rise to any claim against the bank. So that's what the Supreme Court has said about the duty. So in view of that line of authority, what this defence of NEOPHARMA cries out for is a pleading. Firstly, that the instructions weren't in fact authorised, and secondly, that there should have been red flags which put the bank on notice that there was a potential fraud, that these people were acting beyond their authority. There is no pleading, and there is no evidence. NEOPHARMA's evidence doesn't even touch on these issues. And now my learned friend says, "Oh, well, that's all terribly unfair because we're not relying on the Indian proceedings anymore." And he thought that was all that was relied upon. Well, I'm afraid that was a very, very serious error. And it should, with respect, have been obvious to NEOPHARMA and its lawyers. The bank was seeking immediate judgment on the basis that it advanced large sums to NEOPHARMA which had not been repaid. The Indian proceedings were only ever relied upon against Mr. Shetty in rebuttal of his defence that he hadn't signed the guarantee. And they have nothing to do with NEOPHARMA, and it's irrelevant to their defence whether or not his signature on his personal guarantee was forged. And my learned friend has actually said this in his skeleton. I mean, if a respondent to an immediate judgment application wants to say, well, you shouldn't give immediate judgment because there may be further evidence available at trial, it's incumbent on the respondent to set out at least general terms the nature and source of the evidence and its relevance. And NEOPHARMA hasn't done that, although this application was issued in July last year. And as I've said, they made a point of applying for an order for production of all the payment instructions and supporting documents. And those were provided to it on the 27th of March last year, and again on the 20th of June. And it's done nothing with them to attempt to substantiate its claim of fraud. And that means there's no evidence before Your Honour to make good the basic building blocks of its defence. But there's a couple of other brief points that I would like to address, raised by Mr. Koshtel and his skeleton. Firstly, it said, NEOPHARMA does not accept that the facility agreement and the sanction letter evidence a concluded agreement. You see that at page 58, which is paragraph 12 of the defence. It said there, 12.3, the documents do not bear the characteristics of being genuine loan documents produced by a commercial bank. For example, the head note of the sanction letter overlaps with the text of the letter, and the text itself is not properly aligned. Well, and we've looked at the facility agreement. The facility agreement is obviously an absolutely boilerplate standard facility agreement of familiar sort. Let me deal with the 3 points here. 12.1, it says the fourth defendant has no recollection of signing the documents on behalf of the first defendant. I have no idea what that's based on. I mean, there's no statement of truth. This is NEOPHARMA. I mean, who knows? There's no suggestion that there's absolutely no basis for saying how they know that, other than seeing that it's set out by Mr. Shetty in his own defence. Then it says a forensic report commissioned on behalf of the first defendant has concluded the fourth defendant did not sign the document. There is no such forensic report. As far as I'm aware, NEOPHARMA has never commissioned a forensic report. Then it said that they don't bear the characteristics of being genuine loan documents, and that's the only particular. Now, if you look at the 157, which is the sanction letter, you'll see the point that's being taken. It's a little bit wonky. Someone has put the paper in the printer in a slightly wonky fashion. And it said that shows this is not a genuine banking document. How absurd, in my submission, as a defence to a claim for repayment of $30 million. Now, the second point that's made is, well, the requests to draw down the loan were not made in the form of the utilisation request template. Well, I mean, again, I think my learned friend needs to show you whether that's the case or not. I mean, he hasn't put in the evidence and he doesn't want me to show, Your Honour. But I will say that I think it's common ground that the precise template form was not used in the facility agreement. But I mean, yeah, as Your Honour saw, it wasn't a mandatory requirement of the facility agreement. It was really for the bank to be content that the requests submitted to it were for sums within the facility, were supported by documents, were signed by someone whose authority had been confirmed. And it's really no answer for NEOPHARMA to rely upon its own decision not to submit payment instructions in the form of the template and say, well, that excuses us from having to repay $30 million. I mean, how is that? What's the legal basis for that extraordinary argument? And then also it said, well, the bank shouldn't have advanced the money because it didn't receive the possessory pledge of, you recall there was a promise to provide a possessory pledge over machinery and equipment within 3 months of that being installed. And that was a condition subsequent, not a condition precedent. So the bank actually wasn't entitled to refuse payment on the grounds that the pledge hadn't been provided. I haven't taken Your Honour to it, but there's quite a lot of correspondence exhibited to Mr. Chowan's witness statement where the bank says with some agitation to NEOPHARMA, when are you going to provide this pledge? And they keep getting rebuffed and never is provided. But it's extremely unattractive for NEOPHARMA to say, well, we haven't given the undertaking and therefore more fool you for advancing us the money. I mean, what kind of argument is that? I mean, no legal basis for it has been pleaded. In any event, the bank had ample other security. It had taken 2 corporate guarantees and a personal guarantee from Mr. Shetty. It didn't know, of course, that in 2017 that the NMC Health Group was going to become insolvent 3 years later. So I'm not going to say anything more about NEOPHARMA's defence at this stage. If I say it doesn't begin to raise a defence which ought to go to trial. Now, turning then to Mr. Shetty's defence, he of course is relying on his usual defence that he didn't sign the facility agreement or the facility or the PG or any of the corporate guarantees or any of the undertakings or the sanction letter or any other of the large number of documents which bear his signature. And as usually says, well, somebody else may have forged, I can't exclude the possibility somebody else forged my signature. I don't know who that person was. Well, I mean, it's been nearly 4 years now. I mean, this defence really ought to be called the Shetty Special because it's trotted out with such wearisome regularity by Mr. Shetty in his many proceedings in which he's being sued by a bank on his personal guarantees. But it's not limited to Mr. Shetty. It's an unattractive feature of litigation in this court and in the onshore courts that when guarantors are called upon to honour their commitments to pay very large loans, turn around and say that they don't want to, they don't know anything about it, and they want to instruct a handwriting expert. And that really is the last refuge of the desperate, in my submission. As your lordship has already noted, he hasn't himself provided any witness statement, and he's preferred to shelter behind his lawyers. Now, there is, as you know, there's a practice direction number 1 of 26 in this court, says that lawyers should not give statements unless the contents are formal or uncontroversial, or submitted solely for the purpose of introducing documents without giving factual evidence on the merits. Mr. Shaheen's witness statement is extremely argumentative and blatantly contravenes the provisions of that practice direction. Where is the evidence from his client? Now, the bank's taken the precaution of obtaining its own expert handwriting report. That's at page 633. And it's from Mr. Abdel Majid, who is an experienced forensic document examiner who's given evidence in court on many occasions. And this is the instructions which were given to him. And he was asked by the bank to compare the disputed signatures on banking documents with known signatures of Mr. Shetty on his passport and ID cards. And the report itself follows from page 634. So, I mean, I can, your lordship may want to look at that at more leisure, but the conclusion really, I mean, he says he's compared, he's carried out various tests, measurements, experiments, and then he says at paragraph 13, it is my professional opinion after examination of comparison of the above described documents, the signatures on items 1 to 6 were signed by Dr. B.R. Shetty, whose specimen signatures are contained in items 1 to 4. And items 1 to 6 are the 1 is the facility agreement, 2 is the corporate, 2 and 3 are the corporate guarantees, 4 is the PG, 5 is the sanction letter, and 6 is the undertaking by NEOPHARMA that it will execute a pledge. Now, what Mr. Al-Majid doesn't say in terms whether his conclusion is conclusive, which is the terminology that forensic document examiners use, but he does express it in clear and unqualified terms. And he goes on following paragraph 13 to explain his reasoning. And in particular, he says, he talks about excellent and significant agreement between the relative size, slant, skill level, stroke designs, loop spacing, and so on. And then he notices that the next paragraph that the disputed signatures are freely and rapidly written, which is, in my opinion, one of the most important aspects of genuineness. And so he says those are the factors that lead to his opinion that he was the person who signed them. Now, Mr. Albar, well, I'm really source for the goose and source for the gander. I do object to the admission of the actual expert report. But
when did you first see it?
On Thursday, when the skeletons were exchanged. So,
Well,
what I am
do you want an adjournment to answer it?
No, I don't. But in any event, what I'm content, Your Honour, to rely upon is what Mr. Shaheen says about it in his witness statement. So that is at page 599, okay, which of course I have seen some time ago. Yes. So there we are. So he summarises it, he explains the background, and then there's a summary at paragraph 24. Now, what you'll see here is that this is largely doesn't even purport to be a handwriting expert. It's expert evidence. I mean, it's really comments about the way that the documents have been signed or unstapled. I mean, you know, he's not an expert in the execution of banking documents. I mean, look at the first one, for example. He says the original facility agreement dated the 14th September. The document lacks Mr. Shetty's signature initials on each page. Well, it's got somebody's initials on. I don't know whose they are. And I mean, that's true. But so what? What requirement of law is there that to be enforceable, the facility agreement must be signed on every page? I mean, it's been stamped and initialed on every page. And then, I mean, why don't we have a look at that? Why don't we look at page 163 and you can see that?
Well, page 71 of the document is also referred to. Can you tell me where?
Yes, well, absolutely. Yes. Well, let's look at that. Well, that's wrong. That's at page 234. He says that's not been signed. Well, I mean, that's just not true. If you go to page 234, and you can scroll down, you can see this is page 71 of the document. It has been signed and stamped.
But then should we construe then what Mr. Shaheen is saying of Mr. Al-Bar is that he doesn't regard that signature as genuine?
Well, good question. I mean, who knows? When he says it hasn't been signed, I mean, it's hard to say whether he's saying it's not been signed.
Well, if you go to the page, there is clearly an apparent signature.
Well, quite exactly.
So wouldn't then one construe Mr. Shaheen's statement as saying, well, Mr. Al-Bar is saying that the signature is not genuine?
No, I you know, the reason why I say that is because I think Mr. Al-Bar is referring to a different page, which is hang on, no, because there is a signature page. Here we are. Yeah, I think he's referring to page 223. Because this is another point.
He says page 71 of the document.
I know, but that's really my point. Let me show, I mean, he's not a very competent expert in my submission. He's got the page number wrong. I suspect that what he's referring to
either that or he's saying that this is not a genuine signature.
Well, I mean, maybe, but can I just show your lordship page 223? I mean, we can only speculate. You know, he hasn't given. You know, but
what's he saying in the actual report?
Well,
if that's in evidence.
Why don't we just look at the report? I mean, I have been objecting. Why don't we simply look at the report? That's probably the easiest thing. Which is at now again, I might have to rely on Mr. Shaheen to tell me which page we find it at. It's at the very end of the bundle. I know that.
Page 1389.
1389. Yes, thank you very much. Yes, that's very helpful. Yes, there we are. So let's just look at it. Let's just look at it. It's not ideal, but there we are. It's 24th of July. So, and he says, okay, so if we scroll down, 1391, some samples of valid signatures that we've relied upon in previous cases. Well, that's unsatisfactory. And then he says,
why is that unsatisfactory? Why is that unsatisfactory?
We don't know what they came from. I mean, it's just an assertion we have relied upon. I don't want to give evidence, but Mr. Al-Bar has given evidence in other cases involving Dr. Shetty.
Yes.
But
I assume what he's saying is these are signatures which I have been instructed we can take as genuine.
Yes, let's assume that. In his favour. So then he says there are some signatures written by video technology on the 17th of April. I mean, again, perhaps someone took a video of that. Anyway, and that's his schedule.
Yeah.
And yes, to be fair, I think you may be right, Your Honour. It says page 71. I think perhaps you're right when he says the signature does not match with the specimen signature of Dr. Shetty.
Yeah.
But what is puzzling, he says no relation between signatures attributed to Dr. Shetty on last page and prior pages. I mean, that's odd because there aren't any. There's only one signature on the facility agreement, so that is a meaningless statement. And then he says Dr. Shetty missing on several pages. I mean, again, you know, the key points are this: it is signed on page 71. He doesn't point to any legal requirement that it should be signed anywhere else. To say alterations or additions could occur is just improper speculation.
But he does say the signature does not match with the specimen signature of Dr. Shetty.
He does, but you will look into
why doesn't that give rise to a tribal issue?
Because there's nothing to support it. And the whole of this document is, I mean, look, because there's literally no reasoning in this expert report. You look at it, and there's literally nothing in it to explain what he's done. I mean, look at it. If you go down to page 1400, I mean, it's all over. I mean, a very large number of known signatures have been presented. I have an opinion that some of the signatures are inconsistent. Numerous documents not headed nor stamped. So what? Most documents kept accompanied by many inaccuracies, negligence, and lack of completion. None of his business. He's not a banking expert. Signature on page 16 has been on personal guarantee mostly has been signed by Dr. Shetty. What does that mean?
You skipped that. So can I just take you back to paragraph 2? Some of the signatures as listed in the chart above is inconsistent as regards to Dr.
Yes.
Shetty's signature.
So he says,
so
absolutely.
He's saying there that some of them are forged.
Well, so he said, well, yes. What I wanted to show, Your Honour, is that there's no reasoning, there's no explanation of why he considers that to be so. And what you have is a number of really improper speculations about things that are entirely out with his expertise, such as saying, well, there's no signature or seal on the bank on all pages. Well, true, but irrelevant.
Can you just look at item 5 on that page?
Yeah.
Mostly has been signed by Dr. Shetty, but can't be accepted as earlier pages has no initials or signatures of document. And then it goes on, compared to the specimen signature of Dr. Shetty, the signatures on this page does not appear to be genuine.
Yeah. But why not?
Maybe forwarded based electronically.
Well, yes.
Well, but it is an assertion of forgery.
Well, it's an assertion, but again, if you go back up to where he deals with this, I mean, item 5, page 1393.
Yes.
I mean, this is really hopeless. I mean, if you're going to come along and say to this court, my signature has been forged, you need more than trotting out someone who says, well, I think it's been forged. I mean, there's nothing here. Look at it. He says one signature found on page 16. Again, so what? Bank and NEOPHARMA seal stamp are missing on all pages. So what? What business is this man speculating on this stuff? He's got literally no business expressing an opinion on any of this. And he says it's been removed and restapled several times. Again, so what? Again, that's utterly improper for him to purport to express an expert opinion on that. It's got nothing to do with his supposed expertise. And unsigned pages are susceptible to additions and alterations. All we have here is one sentence. Compared to the specimen signature of Dr. Shetty, the signatures on this document do not appear to be genuine. That already said it's singular, not plural. It raises suspicious concerns. It may be forged or placed electronically on this document. I mean, those are two different things. Is it forged, or is it a genuine signature that's somehow been copied and pasted in a fraudulent way? I mean, which is it? It may be forged. I mean, that's a hopeless basis. This man's supposed to be an expert. He should express a conclusion. First of all, he should set out his methods and the inspections and tests he carried out, and then give a reasoned explanation as to conclusions. A sentence of assertion saying that it may be forged, in my submission, is not a sufficient basis to say this ought to go to trial. I mean, you have to look at the sort of the inherent plausibility of the whole thing, really. I mean, it's not just a signature of one document. It's a whole series of documents. It's a very, very elaborate fraud that's taken place on Mr. Shetty's case. And yet there's nothing, not even a witness statement from him denying that it's a signature. I mean, even his defense doesn't go as far as saying it's not his signature. He just says, I can't exclude the possibility that someone may have forged it. I mean, that's just hopeless in my submission. There's an allegation of forgery. I mean, these are serious points. I mean, I mean, my skeleton, I refer to the Albus Rowe case. I mean, there needs to be some sort of evidence. I mean, the burden on the bank is on the bank, obviously, but there needs to be some sort of evidence. This is not evidence that deserves serious consideration by this court in my submission, my lord. I mean, it's just a hopeless attempt to try and defer the inevitable. You know, and you can, I say, to take judicial notice of the fact that this is always Dr. Shetty's case. And that, in a sense, you know, it's almost taking the court for a fool, expecting the court to accept this extraordinarily extravagant theory without any proper expert evidence. It's preposterous. It's preposterous. It's an utterly insufficient basis for saying that there ought to be a trial of this case. I mean, there are a couple of other points which have also only emerged in Mr. Shaheen's skeleton, which haven't been pleaded, but we ought to look at, because there's a suggestion that Mr. Shetty is entitled to rely upon Article 1061 of the UAE Civil Code. And I think the short answer to that is that the UAE Civil Code doesn't apply in the DIFC virtue of Article 3.2 of the Financial Free Zones Law. And there's some, I mean, again, Mr. Shaheen will take you to his arguments. I mean, there's some sort of suggestion, well, this might have to be, this judgment, if you give it, might have to be executed in Abu Dhabi, because that's where his UAE address is. Well, he's not, everybody knows he's in Karnataka. But I mean, the place of execution doesn't govern the law. I mean, as we've seen, this guarantee is governed by the laws of the DIFC, which excludes the application of UAE civil and commercial laws. And similarly, there have been attempts to rely upon Articles 390 and 391 of the UAE Civil Code, sorry, the Civil Procedure Code, but that doesn't, again, the court's had a number of occasions that simply does not apply in the DIFC. So when it comes down to this, I mean, really the only defence advanced by Mr. Shetty is this: he hasn't signed, he hasn't put in a witness statement to affirm the truth of his defence. He hasn't even said in terms, I did not sign this, it was forged by somebody else. And he's produced frankly, a tame expert report that doesn't set out any basis for the assertion made, no explanation of methods, unlike the Mr. Abdul Majid report, which is a proper expert report and does explain the processes he took out, he conducted, and the basis on which he concluded that all the signatures were genuine. And I also invite your lordship to consider the inherent probabilities that all of these, I mean, it's such an implausible and flimsy suggestion. You know, one, as I've said, is wearisomely and routinely trotted out by defendants in this court. You should ask for some form of evidential basis before giving the defendant the indulgence of a trial. I mean, it's just, as I said, it's a cynical, desperate defence, the last gasp of a respondent that knows he's got no answer to the defence. And it is simply a waste of everybody's time and money, and the time and money of this court not to put this defence out of its misery now and give immediate judgment against both defendants. But those are my submissions for the moment, my lord, subject to any questions you have. But I'll obviously reserve my right to reply. Thank you.
Certainly, Phil. Thank you, Ms. O'Sullivan. Well, Council, we've been going for almost 2 hours. This might be a convenient time for a break. Should we break 10 minutes, 15 minutes? I'm in your hands. 10 minutes?
10 minutes is good.
All right, we'll adjourn. We'll resume on the hour. It's 51 minutes past the hour, so we'll resume, or 53. Why don't we'll resume in 10 minutes anyway. Leave the lines open and we'll come back in 10 minutes. Thank you.
Thank you.
All right, well, I think they're all reassembled. Mr. Costello, would you like to go next?
Certainly. Thank you. Well, I'm not going to repeat the submissions I've made earlier on the way the application was presented. Those points I think I've made substantially enough already. You would have read in our skeleton that we say that would be alone sufficient reason for the application to be refused. However, again, not to repeat myself, if you take the view that the application should be heard nonetheless, then I go on to deal with the points at paragraphs 35 onwards of my skeleton argument. Excuse me. There are a number of issues in this case. One of the main ones was last touched upon by my learned friend and my lord in reviewing the expert report. In my submission, it's reasonably clear whether you look at the report or Mr. Shaheen's witness statement, which is a reproduction of the report. There is clearly a tribal issue. Whether or not the expert ought to have presented his opinions in a different way, these are all methods for my learned friend to cross-examine at trial and to make closing submissions.
The case against you is not that it should have been put in a different way. The case against you is that there are no opinions. There are conclusions. There's no opinion with an enunciation of the process of reasoning. And there's certainly authority in Australia, and I suspect in other common law jurisdictions, that the enunciation of the process of reasoning is a critical part of expert evidence, because otherwise the court has no means of evaluating the correctness or otherwise of the opinion expressed. And if you go to the report, which is the fullest statement of Mr. Albar's opinion, it is a series of conclusions, and he doesn't describe what he's done. He doesn't describe the basis for the conclusion. So I think what's really being said is that this report is not, it's not just a matter of cross-examination. Ms. O'Sullivan didn't put it in these terms, but I think what she's saying is this report is so bad it is of no weight, and doesn't provide a sufficient basis for going to trial. How do you answer that?
The answer I give is that he's set out at 1391 of the bundle, which I think sorry, 1391.
Yes.
Oh yes. Okay. So
yeah. Yes.
He set out a list of known signatures, and then he set out 3 sample signatures. It's reasonable to infer that he's clearly undertaken a comparison, which has resulted in the opinions he gives or the conclusions he gives on the following pages. Now, at trial, what is reasonably expected, and I admit that perhaps my learned friend for the 4th defendant needs to make this submission good, is that not only will Mr. Albar give evidence, but he would have given either a fuller report or a witness statement, or both, outlining exactly the methodology, how he came to give his opinions, how he compared the signatures, all the matters that we are accustomed to seeing. Now, whilst it may be absent from this specific report that we have before the court today, it is evidence that is reasonably expected to be forthcoming. But I'll have to defer to Mr. Shaheen on that. But nonetheless, I ask you to bear that in mind when it comes to considering the report and its conclusions, most notably saying on the where possible, for example, Dr. Shetty didn't sign X signature on this particular document, and in other respects, it doesn't also discount the defense that Dr. Shetty signed, that it could be Dr. Shetty's signature, but he is not the one who actually signed it. So, for example, it would be cut and pasted onto another document. It may be his signature. It may be that he signed it once upon a time ago, but it may not be that he applied the signature to that particular document. And I think that's a very...
if it's cut and placed on a document with his authority, then that is his signature.
Yes,
so
but assuming he's given...
He would need to say, if that's the scenario, he would need to say, and the person who did this did not have my authority.
Indeed, I agree with that. I agree with that, and I respectfully submit that that is evidence that's reasonably expected to be forthcoming at trial. And we can take that.
Or except that I would have expected Dr. Shetty to have already said something about these documents, and he said nothing about them.
Yes, as I said before, that may have something to do with the way the application was first presented. But that aside, the witness statement from Mr. Shaheen, who has said in his witness statement, I can't remember the exact paragraph, but it's based on instructions, is that he has denied that he's the one who has signed it. And in any event, unless I'm mistaken, I think he's also the one who signed the defense. So I'm just going to double check the 4th defendant's defense. Yes, page 53 of the bundle.
That.
So page 53 of the bundle is the statement of truth for the defense. Right. And that's Dr. Shetty giving that statement of truth. So in the circumstances, yes, I take your point. I take your honest point that there isn't a witness statement currently before the court from Dr. Shetty, but it's a witness statement that is forthcoming. Again, I have to divert to Mr. leave that for Mr. Shaheen to make good on that submission. But it obviously has a bearing on the first defendant's case, given that the first defendant does dispute the signatures that appear on the facility agreement, sanction letter, and other documents which you're familiar with.
But none of that. The fact that the signatures are contested would not be a defence to the first defendant if the first defendant received the money, would it?
Well, then that will depend upon whether or not there is a fraud taking place, to the extent that the money is received, to whom is it received, and who authorised that the receipt of that money.
But the problem is that there is absolutely not a jot of evidence to sustain the proposition that the payments were anything other than regular.
Yeah. The two arguments I have, the two responses I have are, again, a repeat of what I said before, which is the application was premised on a different basis, and that of itself did not cater or did not allow the a response to cater for that point. But secondly, it is evidence that that can be forthcoming in a witness statement. So a witness from the first defendant stating, having reviewed the documents now, etc., these were unauthorized payments, and there is certainly that there is it is the claimant's case that at some point in 2020 payments stopped. Now I'm sure my learned friend is saying, of course the claimant is saying, well, that was default, but on the other hand, that does not discount the potential defense that those payments stopped because of the fraud, as in the fraud is uncovered and repayments are stopped.
But the loan was serviced for 2 years.
Sorry?
The loan was serviced for 2 years before that happened, which
Yes.
seems improbable if somebody was defrauding the company of all that money. Anyway.
Well, improbable or not, that's not a point that can be taken on immediate judgment in my submission. It's about whether or not there is a realistic prospect of successfully defending the claim. Now, whether this is a point for trial, I admit that's a point for trial. These are points that have to properly be raised at that point. But at this stage to say, well, so it's improbable and therefore immediate judgment against the first defendant, in my submission, that can't be right. There is enough there to see this case through to trial, and on evidence that is reasonably expected to be forthcoming.
Yes.
Sorry, I'm just glancing down at my skeleton argument. Yeah, those are. I don't want to repeat what I've already said in my skeleton. So that was a way of amplifying that point. Can I deal with the drawdown requests and take you to clause 5 of the facility at page 176 of the bundle?
Yes.
This is from the facility agreement, and my learned friend properly took you through clause 5. However, where we disagree is the meaning at clause 5.1, where my learned friend says the borrower may utilize the facility by delivery of a duly completed utilization request, i.e. that's not mandatory, she says. In my submission, the proper way to interpret it is, this clause is that the borrower may, as in has the discretion to use the facility. However, the discretion is not afforded to the way the utilization request is made. That is, on the face of this agreement, not covered by the discretion. That utilization request, because it's catered for clearly within Schedule 3, if I'm not mistaken, is the proper way for a drawdown request to be made. And that of itself.
It all comes back to the question of authority, doesn't it, Mr. Costello? If the person who made the request of the bank had the authority of the company to make the request, and the bank honoured it, it wouldn't matter whether the request was made in the right form or not, would it?
It would, because if it's not made in the right form, then that's a red flag, we say. And that, I think my learned friend has fairly accepted that the requests were not made in the format of Schedule 3.
Why would that be a red flag? A fraudster could just as easily make the request in the right form as not, couldn't they?
I'm so sorry, I'm having trouble hearing you. Why is that a red flag?
Why would a lack of strict compliance with the form give rise to a red flag? Because if the person was intent on fraudulently misappropriating the company's money, a smart fraudster would use the form.
Well, a smart fraudster would potentially have access to the form. A smart fraudster may try and do it as close to the book, if I like, you know, inverted commas. But we're assuming there's a smart fraudster. We're not. A fraudster could be equally inept at being a fraudster, or just not that sophisticated. Which, frankly,
or a person with authority could simply not use the right form.
And that may well,
isn't it?
And that's one of the explanations that's proffered by the claimant. But it's the fact that we've got multiple explanations based on, so far as the defense is concerned, in terms of whether there's a realistic prospect of success, based on the wording of Clause 5 and the way the requests were made. One obvious point is, and this one just jumps out at me because I'm reading Clause 5.3, the currency specified in the utilization request must be US dollars. The utilization requests were in dirhams, and then it says the figure stroke. Sorry, I heard something.
But you're relying on Mr. Chauhan's second affidavit now, Mr. Boschtel.
Yeah. I mean, are we going to look at the documents or not, is my question.
Are you relying on Mr. Chauhan's second affidavit for that submission?
No, there's a section C, documents, and it's got the drawdown request at page 726.
Right. Are you happy for us to look at those, are you? Okay, well, that was saved a lot of argument.
726, is that a document attached to Mr. Chauhan's statement?
No, it's not. It's a document that appears in section C.
All right.
Section C, okay.
Well,
so I'm
very content for Your Honour to look at those. That's fine. If there's no objection to that, that's fine with me.
I don't understand why my learned friend is intervening, because these documents were not annexed to Mr. Chauhan's second witness statement. Okay. So can I ask for some clarification on why, for the interjection?
Well, I think there's
yeah. I mean, if my learned friend is content for me to refer to the documents in section C, I'm content.
The documents in section C were not exhibited to Mr. Chauhan's second witness statement.
Well,
what is section C? Can somebody help me with that? What is section C?
It's just listed documents.
Right.
I mean, I don't want to tease my learned friend here. Let me help him a little bit. It does include the documents in section C. Sorry, it does. There's a complete overlap. The documents in section C are also the documents in Mr. Chauhan's statement.
All right. So Mr. Costello, you have no objection to reference being made to the documents in section C?
Your Honour, no, I don't. The documents there was a specific objection taken to Mr. Chauhan's second witness statement and the exhibited exhibits.
All right. So, well, that's clear then. So there's no objection to the documents in section C. All right. Thank you.
Now, as I was saying, I was talking about the currency, where the currency stipulated is Arab Emirati dirham, and then / inequivalent USD, and that was just an obvious example. I was saying that just jumped off the face of the facility agreement. Anyway, my point was very simple.
The request is we paid in Arab dirham, and the exchange rate fluctuates, so pay us in whatever the equivalent rate is at the time you're paying us.
No, I think the dollar's pegged to the dirham, but in any event, yeah. But the point here is that the point is actually far more simple than this, which is that as my friend has already accepted, the utilization request made was not in the form that was agreed in the facility agreement. Yeah. That's the only point that we're making on behalf of the first defendant. That we say should have given rise to red flags, potentially anyway. Let's bear in mind, we're not seeking immediate judgment on this. We're saying that this is a tribal issue.
Yes.
Your Honor, those were really my points, because the majority have already been made beforehand, and they have already been made in my skeleton argument.
Yes, all right. Thank you, Mr. Costa.
Thank you.
Mr. Shaheen. I can't hear you, Mr. Shaheen. I think you're still on mute.
Sorry, Your Lordship. Thank you very much, my learned friends. It was very helpful to hear your submissions. Your Lordship, I may straight go to the expert report and highlight some of the findings there. Because the initial point, which is the reliance on the proceedings in India, which formed the basis for the first witness statement of Mr. Sunil Kumar, and also the basis for the application for immediate judgment has been withdrawn now. So I don't want to elaborate on those provisions. I'll straight go to the expert report and highlight some of the points stated in the expert report, Your Lordship. As my learned friend rightly pointed out, in the expert report, which is page number 1390 I'm referring to, he has expressed his willingness to provide a witness statement to the DIFC court if required. This is one. He has also stated the last line, if required, appear before the DIFC court as an expert witness for cross-examination. He has expressed his willingness to do all that. But this is possible only if there is a trial, is my humble submission. We cannot go for all this in an immediate judgment application, and that's where I got stuck. Now, coming to page number 1391, Your Lordship.
I'm sorry,
the signature...
just slow down. Just repeat what you said where you got stuck. What was that about?
Because when there is an immediate judgment application, there is no scope for a trial for me to bring the expert as a witness and subject him for cross-examination to produce his witness statement and follow the other formalities here, Your Lordship. Now coming to 1391, next page, Your Lordship. Known signatures from 2013 to 2020, 2016, all these years are shown there. He has taken it from various sources. And then Dr. Shetty's sample signature written live by video technology on 17/4/2020, they were consistent with the upper samples. He's confirming that. So it's incorrect to say that he has not stated the methodology at all. Now, I will explain later the limitations, the constraints faced by this expert, because I was personally present during the inspection. I can say that, and I have stated it in my witness statement too. Now, coming to the technical inspections, which he has remarked, which very few I have highlighted in the skeleton argument and also in my witness statement earlier. Here, the original facility agreement dated 14/9/2017, which should form the basis for the bank's claim even against D1, not only D4, even against D1, Your Lordship. Here, my learned friend pointed out page 71 has not been signed by Dr. Shetty, and there was a signature. Why it is stated not been signed by Dr. Shetty? If Your Lordship kindly look at the next column, status of signatures, fourth bullet point. No relation between signatures attributed to Dr. Shetty on last page 71 and prior pages. So that is why he is saying that page 71 is not signed by Dr. Shetty. This is what I would infer from this and answer to my learned friend and statement that this is not an incorrect statement. When he says it's not signed by Dr. Shetty, he means it's signed by somebody else. And the reason he has stated in the next column, Your Lordship. And then other findings, Your Lordship, we did not find any signature or seal of the bank on all pages. There are no technical issues linking signatures attributed to Dr. Shetty.
Just what does no relation between signatures attributed to Dr. Shetty on last page and prior page? What does no relation mean?
I will not be able to conclusively answer that question because it is for the expert to answer, Your Lordship, but I would infer that on the prior pages, some of the pages, if not all pages, the signatures were there of Dr. Shetty. There is no connection between the two. It looks totally different, could be the only inference possible. I'm just going by a logical interpretation because I cannot speak on behalf of the expert. It is his statement. I'm only trying to find a reason why he stated by page 71 has not been signed by Dr. Shetty when we are actually seeing somebody's signature there. But he is concluding no relation between signatures attributed to Dr. Shetty on last page 71 and prior pages.
All right, just
Initial
what is page 71 again? What's page 71 in the bundle?
71, can you take?
What is
53, page number 53 is the facility document, I believe. No, it's not the page number.
Page 234.
234, thank you.
It's a little
All
slow.
right. Page 71. All right. Now,
That's what is stated in the expert report. I'm trying to relate why he stated there is no signature when there is actually a signature. He's saying it's not signed by Dr. Shetty, but the signature doesn't tally or match. Now,
where are the prior signatures of Dr. Where are the prior signatures of Dr. Shetty to which there is said to be no relation?
And prior pages is what he has written there. No relation between this one and the prior pages. The previous pages, somewhere the signature must be there.
Dr. Shetty hasn't signed any of the prior pages.
I'm just opening.
We are looking at it, Your Lordship. So that is all I can say about this finding, Your Lordship. Maybe it was not in the document, could be some other document, sanction letter, other documents could also be that. Now, the last line in that...
That's the problem, isn't it? If we're going to send this case off to trial on the basis of an expert report that doesn't make any sense on its face, that's not very satisfactory, is it?
We can cross-examine the witness, the expert, and we will bring out the truth.
The question is whether there is enough evidence to justify a trial. And
I will come to
it when he refers to no relation to prior signatures and there aren't any prior signatures. It doesn't make any sense.
Page 71 only, I can see there is only one signature there of Dr. Shetty and then the lender, 234 page number. This is what I would say, page number 71. The previous pages he has stated initial signatures are forged. This is the next line, Your Lordship, on the status of signatures on the column against the original facility agreement dated 14/9/2000.
What's he referring to with the initials? What are the initials?
Initials signatures are forged. Initials on all pages are there. Many of the pages are there. And he is conclusively stating that.
What are the initials? What are the initials?
Initials are the small signatures put on the previous pages.
Right above the stamp.
All right.
Right.
And those are the ones on top of the stamp of NEOPHARMA.
Yes, there is an initial there, and he is saying initial signatures are forged.
Show me an example of one. Show me an example of an initial that the expert is referring to.
That only for the expert to answer, Your Lordship, I can't say. He has examined other documents.
You're relying on this report, and if you can't explain it to me, why should I accept it?
Look at the previous column, Your Lordship. Let's not jump into conclusion. Look at the previous column, the last one. Initials written in slow motion with lack of natural variations and hesitations.
But what are the initials? Has Dr. Shetty issued any initials, or is he talking about the person who's initialed each page with the stamp?
The only initials I see on the facility document is on the NEOPHARMA stamp. And those initials purportedly attributed to Dr. Shetty because he is the person signing on behalf of NEOPHARMA on the last page. The assumption is that the initials should be that of Dr. Shetty. And he is conclusively stating that initials are forged. And the previous column, he is giving the basis for that statement, that conclusion, initials written in slow motion with lack of natural variations and hesitations. I would say this is a maximum I can expect from an expert report. Why is he saying that is stated? The statement finally, status of signature, conclusive, unambiguous language, they are forged.
Where is that? Where are you saying?
Initial signatures are forged. Status of signatures, item number 1, original facility agreement, last column, last line. On page number 139.
But there's no explanation for that.
Explanation is on the previous column, Your Lordship. Initial
handwritten in slow motion with lack of natural variations.
Yes, sir. It's very clear explanation given. Why is he concluding that they are forged?
Yes, all right.
So it's a clear case of forgery only by this line, and the conclusion is unambiguous. The reason why he concluded to that effect is clearly shown in that expert's comments on the documents. He has given that very clearly. Now coming to the next document, the original sanction letter dated 12/9/2017. The first column is signatures are found only on page 6, or only no signatures on earlier pages. Prior 5 pages signed and stamped by bank only. Only signed by one party to the document. The other party is not signing that document. And his status of signature, unsigned pages are
Dr. Shetty did sign the document.
only on the 6th page.
Yes, so what?
The 5 pages. So the previous document, facility agreement, it's clearly stating that the signature or initial on all the 70 pages are forced. And the next document comes, no initial, no signature at all. Only the last page. And the expert says this unsigned pages are susceptible to additions or alterations at any time. Not reliable evidence.
There's no evidence that there were any additions or alterations, is there?
There were no initials at all, Your Lordship. There were no signature at all on 5 pages. It was in the bank's possession. They could have changed it, altered it any time, is what the expert is saying.
That's my point. There is no evidence that the bank ever did add or alter those pages, is there?
There is no way that the defendant could bring any evidence either. There is no possibility. It happens in the bank's office. We cannot say what happened there. We are only looking at
just complete speculation without any basis in the evidence.
all we can do, Your Lordship. We are examining the documents produced before the Honorable Court, the veracity of those documents, the genuineness of the signatures on it, the reliability of those documents, examining the quality of evidence produced before this Honorable Court, especially when an immediate judgment application is filed without trial. I am denied the principle of natural justice, audi alteram partem. I must be heard. Being heard, being sufficiently heard, not just giving one opportunity. And we are not even supposed to conduct a mini trial here. So I need a trial, a proper trial to examine all this. And I did not come with an immediate judgment application to dismiss the bank's claim. If that was the case, what Your Lordship said is absolutely correct. I am not able to ask for an immediate judgment dismissing the bank's claim based on this expert report. I can admit to that effect. But the bank's application for immediate judgment is certainly challengeable. I have strong grounds of defense, which can only be taken in a proper trial. I should not be denied an opportunity, is my humble submission. Now, original corporate...
Mr. Costello says that I should assume that you will augment this evidence by either another expert report or by a witness statement from the expert between now and trial. Is that your intention or not?
We will be bringing a witness statement from the expert, and the expert has shown the willingness to bring an expert witness statement and subject himself to cross-examination. And I was present during the inspection personally, and the expert report was there. I have asserted in my witness statement what exactly happened, and I have taken the crux of the expert report and presented before the Honorable Court in October. And Dr. Shetty himself signed the statement of defense. So it is not that he has not denied. What I have done in my witness statement is only confirming what Dr. Shetty has stated in his statement of defense, specifically stating that, because it's not my personal knowledge. I stated, Dr. Shetty stated in his statement of defense, so and so. And I've stated what exactly happened during the inspection of the expert, how the inspection was conducted, why he was restrained. Only one day, one chance. A second chance was requested. They refused. The counsels of the claimant refused an opportunity. He said, you go to court and take another order. By the time comes the immediate judgment application also. Now, the original of the corporate guarantee, Your Lordship, only one signature on page number 12. And this is all very alarming, especially since the main document, the facility agreement, all the initials are forged. So when there is nothing, not even an initial, what authenticity can I attribute to the first 11 pages? It can be tampered. The possibilities there is not a conclusive evidence for an immediate judgment. There is no conclusive evidence at all before Your Lordship. The unsigned pages are susceptible to additions or alterations at any time. And the bank seal stamp is missing on all pages. Even that is not there. At least the previous one, the bank had signed and stamped. This one, even the bank has not signed. Then original of corporate guarantee dated 14/9/2017. Mr. Shetty's signature is found on all the pages except page 12. The unsigned pages are susceptible. The bank seal stamp is missing. Same case here also, Your Lordship. And then come to the crucial document, the original personal guarantee dated 14/9/2017, only document to hold Dr. Shetty personally responsible, if at all. And one signature found on page 16 only. No signatures on all ellipses. So 15 unsigned pages to be used against me for an immediate judgment, unsigned 15 pages, which is impossible, Your Lordship. The unsigned pages are susceptible to additions or alterations at any time. I don't need an expert to say this, but I have to bring something before this honorable court to raise this argument, so the expert report is, I'm depending on it. I don't have any other means to say this, otherwise it's simple common sense logic, unsigned pages are not binding. Now,
but that's just not right, Mr. Shaheen. It's just not right to say that unsigned pages are not binding. Documents are commonly produced with multiple pages and signed at the end. And unless there is evidence that the document has been altered since it was signed, that's perfectly valid.
very valid point. Very
in relation to the assertion.
Let's look at the third point. Let us look at the third bullet point in the second column against item number 5. Third bullet point, Your Lordship. The document has been removed and restapled several times. Since the document has been restapled many times, this page could have been attached unknowingly. Somebody is denying the signature. I have not signed this document. He is a businessman. He had multiple companies, multi-billion-dollar businesses. He would have signed many other papers, taking the last page of some other document and putting it along with another 15 pages, or removing and tampering with it, or replacing with other pages. All these are possible, not fit for an immediate judgment. Then, compared to the specimen signature of Dr. Shetty, the signatures on this document do not appear to be genuine. Do not appear to be genuine, unambiguous language. And raises suspicious concerns. It may be forged or placed electronically on this document. What can be more conclusive and forceful than this? Only one signature.
Well, some reasons would be useful. Some reasoning for the proposition that it may be forged or placed electronically on the document would be of considerable assistance, I would have thought, if the court's going to accept that proposition. That's the big hole, the big gap in this report. It's devoid of any reasoning.
Compared to the specimen signature of Dr. Shetty. Compared, that's enough reasoning, Your Lordship. And I was witnessing it, I have seen it, he was looking at it through various magnifying lenses, the specimen signature, this one, comparing it for some time. I've seen it. And well, compared to the...
as I'm sure you're aware, Mr. Shaheen, invariably in an expert report, handwriting expert's report, when they say the signature doesn't appear to be genuine, there is a list of points of difference, so that a comparison will be drawn with the specimen signatures, the verified signatures, and there will be a reference to the upshaft on the X being consistent with this one and it being different in the challenge signature. There's nothing of that sort in this report.
Further, that is a very valid point, Your Lordship. That is why further investigation is required by a court-appointed expert. Here, giving 2 hours.
Mr. Shaheen, there won't be a court-appointed expert in the DIFC court. You can forget about that. That might happen in the onshore courts. It won't happen in the DIFC court.
Yes, Your Lordship. Now, given 1 hour or 2 hours in the counsel's office, only once, one day, and there is an examination and the report has to be submitted, this is the maximum the expert or the defendant could do. The documents are not placed with the expert for further examination. Second chance for verification was denied. What was the bank trying to hide here? Why were they afraid of a proper inspection for a second time? What more can I do? The question I always would raise is a defendant who says he did not sign a document for $30 million. What more is possible from him? This is the maximum I would say. And then original letter of undertaking, signature may be signed on blank page and misused. And all other documents, every document, signatures appear on pages 11, 14, 17 and 19, do not follow the same format as they can attribute to a single person in writing. This is item number 7 on page number 1394, the first one. Then all the document most probably signed by Dr. Shetty on blank paper. The way the document is prepared, on capital letters and trying to fill the space above the signature, this is the conclusion. It appears that Dr. Shetty's signature was obtained on a blank paper and the original promissory note was printed on the blank paper. Signature attributed to Dr. Shetty scanned. Scanned means somebody has copy-pasted it. Anybody can do that. And it appears, the next document, original resolution, appears that Dr. Shetty's signature was obtained on a blank paper and the resolution was printed on the blank paper. Same applies to many documents. Then page number 1395. Item number 12, 10 documents has been taken from original known signature of Dr. Shetty. Such signatures carrying the same features and patterns indicated that they were copy-pasted on these documents. Who copy-pasted? Then 4 signature placed electronically on this document. Rest, all the documents are like that.
How does he know? How do you know it was forged? It was placed electronically on the document. Why couldn't it have been an original signature of Dr. Shetty?
Copy-pasted, Your Lordship. Electronically copy-pasted. You can easily say, I don't even need to be
all the time in modern commerce with the authority of the signatory, and it's a valid signature.
The bank has to produce evidence, not me, that I authorize somebody to electronically copy and paste my signature on some other place. It's not for me. The burden of proof is on the bank. Here it is electronically copy-pasted. Anybody could have done that. I'm saying I never authorized anybody to electronically copy-paste my signature. The contention is very clear. The burden of proof is heavily on the bank, and all the other documents from under item number 12, 1 to 14, all of them are electronically copy-pasted. When the person supposed to be signatory has never authorized anybody to electronically copy-paste any signature. So this is the nature of the documents produced before the Honorable Court. And the summary of the opinion, he has stated that, see, my learned friend read under item number 5, the first portion. I don't understand the meaning of the word mostly there. Signature on page 16 on personal guarantee mostly has been signed by Dr. Shetty, but nevertheless it cannot be accepted as earlier pages as no initials or signature of Dr. Shetty. That word mostly, it doesn't make sense to me. It doesn't carry a specific meaning to me. I admit that.
It is completely inconsistent with the next paragraph.
Then the next paragraph is very straightforward, conclusive, unambiguous language, unequivocally stated. Compared to the specimen signature of Dr. Shetty, the signatures on this document does not appear to be genuine and raises suspicion.
That's completely inconsistent. That's completely inconsistent with the paragraph that precedes it.
The previous paragraph.
Inconsistent expert report.
The previous paragraph, Your Lordship, the problem is with the word mostly. What exactly did he mean?
Take out the word mostly. In the previous paragraph says it's been signed by Dr. Shetty.
Mostly, I don't know what exactly.
Paragraph 5 is hopelessly inconsistent.
It is inconsistent because we are not able to attribute a proper meaning to the word mostly. And the expert, we should understand these are all English as second or third language. Okay, so there is a problem with the word used mostly. But that lack of clarity is completely cleared by the next paragraph, where he is conclusively stating when there is an unambiguous statement, we don't have to go for the ambiguous meaning of a word used in the previous paragraph. It may be forged or placed electronically on this document. That's also very conclusive. So that much the document, which is the personal guarantee, the only document which is supposed to hold Dr. Shetty personally liable, this is the quality of that document. 15 pages unsigned and 16 page forged or placed electronically, the signature. This is a conclusive paragraph. And other conclusion, numerous documents were not headed. Most documents kept to the plaintiff bank were accompanied by many inaccuracies. Then I am of the opinion that some signatures as listed in the chart above is inconsistent in regards to Dr. Shetty's signature. A very large number of known signatures of Dr. Shetty have been presented for it. All this is stated there. And some of the copies of the documents he has appended to that. And signature samples have been shown on page number 1405, what he examined. Then he stated, under the declaration he has stated, my report, this is page number 1407, my report will form the evidence to be given under oath or affirmation. He stated that. B. Questions may be put to me in writing for the purposes of clarifying my report, and that my answers shall be treated as part of my report and covered by my statement of truth. This is what he stated. He also stated, item number E, I may be required to attend court to be cross-examined on my report by a cross-examiner assisted by an expert. Then statement of truth, it's a verified document. I confirm that insofar as the facts stated in my report are within my own knowledge, I have made clear which they are, and I believe them to be true, and that the opinions I have expressed represent my true and complete professional. This is what he has stated. So he has signed the document. It's a statement of truth is there. He is prepared to come before the honorable court and subject himself to cross-examination, even by another expert, he has stated, and his conclusive remarks are there. The documents are forged. And as far as the defendant denying his signature is concerned, who doesn't have access to original documents, even copies have not been provided. We don't have access to any document other than those presented before the court. This is the maximum any defendant could have done before this honorable court. And I'm not asking for an immediate judgment dismissing the bank's claim. If that was the case, I would fully agree with your lordship that my evidence is not sufficient. But in order to oppose an immediate judgment application, only thing I need to show before this honorable court is that my defense is not fanciful. I have a strong defense. I have a prospective defense. I have every possibility to defend this case. So the requirement under the RDC, asking for an immediate judgment, the claimant has miserably failed to fulfill. Now, the judgment produced by the claimant in page number 9 of the application, submissions on his application for immediate judgment, which is the page number, can you see? This is page number 9. Is it the skeleton argument?
Skeleton arguments.
Skeleton arguments.
Yeah.
Submitted on 10 January 2024. It's a skeleton argument. It's in page number 9.
What's the page number in the bundle, Mr. Shaheen?
In the bundle, can you please? I'm just looking at it, Your Lordship. Please bear with me for a second.
Page number 9 is 1062.
1062, Your Lordship.
1060.
1062, page number 9. This Al-Rui case, where the defendant was, just like Mr. Shetty in this case, claiming that his signature on a personal guarantee had been forged. Honorable Chief Justice Zaki Azmi said, this 38 reference number, it is true that at this stage, the appellant is not obliged to produce evidence that the guarantee is in fact forged. I'm not supposed to produce evidence to show that the guarantee is in fact forged. But he must at least adduce something, some ground, basis or fact that can enable the court to conclude that there is sufficient basis to the claim that forgery had taken place. I must adduce something. That is what is stated there. The best what he's saying, Honorable Chief Justice is saying, and easiest method the appellant could have adopted, of course, would have been for him to get a handwriting expert to confirm the inauthenticity of the signature, which is already done. A standard and rather straightforward procedure I have followed. It was not so straightforward, getting the document from the opposite party's counsel's office and doing it all in 2 hours' time without a second chance, for example. But I have done to the best of my possibility. Whatever was humanly possible was done. At the very least, then the Honorable Chief Justice is also saying, at the very least, I would have expected the appellant to produce some evidence to substantiate the possibility that his signature was forged. We have produced the evidence, now expert report itself is there. Or even some demonstration of his conviction in the forgery allegation, much more than that we have done, Your Lordship. A strong statement to that effect with sufficient explanation may have sufficed consistently from the statement of defense signed by the defendant himself, confirmed by the expert report, and also certified or further reconfirmed by me in my witness statement. I was also present during the inspection, and this has been produced before the court. Such steps would not have been very difficult if the appellant solicitor failed to advise him to do. That's a separate remark. I don't want to go into this. So whatever is expected by Honorable Chief Justice while opposing an immediate judgment application, when there is an allegation of forgery and there is a denial of signature in a personal guarantee, I have fulfilled it to my best and more. So this judgment actually is completely in my favor. It proves that this is not a case fit for immediate judgment. That is why initially when your lordship asked me, I was stating that if at all an immediate judgment is possible in this case, all the claims of the banks, whatever is going to come to this honorable court in the future, immediate judgment can be issued. Nothing can be more difficult than this. There are umpteen number of legal issues also which I have raised regarding closure of current account, regarding validity of personal guarantee. All this I have stated. I'm not going into the details. It's all for the trial. It's all for the trial. So at this juncture, when there were only 2 witness statements produced in support of the immediate judgment application by the claimant, the first one, the foundation of it has been withdrawn. The so-called admission before the Indian court from the 4th defendant, the foundation is shaken. They have withdrawn that argument. That witness statement cannot stand without that. Second witness statement, which is submitted now, is also withdrawn. So where is the evidence? Where is the supporting document for an immediate judgment? And the quality of documents, other documents produced, we have clearly examined everything now. The expert has conclusively stated they are forged. The signature initials on all the 70 pages are forged. The signature on the personal guarantee is forged or electronically copy pasted when nobody has been authorized. Forget about the bank, even the people inside the company D1, nobody has been authorized by D4 to place a signature, copy paste. Even a document which they tried to produce calling itself a power of attorney is not a power of attorney under the laws of UAE. If it is enforced in UAE, it will not be considered because it's not authorized. It's just a letter of authorization. And most of the documents under item number 12, 14 documents copy pasted, signature copy pasted. Anybody can do that. And even that much, I would say somebody in the bank has been lazy. They did not do it on the first 15 pages of the personal guarantee. If they could copy paste on the 16th page, they could have done it on the other pages also. It's not done. Maybe it will look identical. Many of the signatures, it exactly looks like a photocopy. No signatures can exactly look the same. Every time the signature, there will be slight variations. But under a magnifying lens, he has found that it has been put with hesitation. The variations are not consistent with the variations that happened during Dr. Shetty's original signature. All this has been conclusively proven, sir. So my humble submission is this will be the last case fit for an immediate judgment. There is no possibility at all for an immediate judgment. It will be a gross denial of justice. It will be a gross denial of the principles of natural justice that both parties should be heard. It demands trial. A trial is an absolute must, your lordship. So the application submitted by the claimant is liable to be dismissed with compensatory costs with indemnity basis for both the defendants who have appeared in this case. It's a clear waste of time. Why is the bank afraid of a trial? See, when that expert examination happened, even before the expert report could be submitted, they came up with an immediate judgment application. Before that, there was a consent order. All of us agreed that it will go for trial in a particular sequence. The moment the expert examination happened, there comes an application for immediate judgment. Just being afraid of a trial, denying an opportunity of being heard. Honorable court should not entertain this. It will be a strong miscarriage of justice if it happens. So my humble submission to be dismissed, the immediate judgment application to be dismissed with costs. That's all, your lordship.
Thank you, Mr. Chair. Ms. Sullivan.
Would you want to give me a couple of minutes just to fetch a charger for my
Certainly.
iPad? I'm a bit worried about running out of charge.
How long would you like? 10 minutes?
No, 2 minutes is fine. I won't be a moment.
2 minutes. All right. Thank you.
Right. Good. Thank you, Rona. That should be sufficient to ensure I'm not caught mid-flow.
Good, thank you.
Thank you. I will address first of all Mr. Kostel's submissions on behalf of NEOPHARMA. First of all, I don't believe he's addressed my submission that it's irrelevant whether Dr. Shetty's signature on the personal guarantee is forged, and it's also irrelevant whether his signature on the facility agreement is forged, in the absence of any allegation that the bank knew or ought to have known it was forged.
I think his point is that they want to investigate whether the signature on the power of attorney is forged.
Yes.
And it's the power of attorney that authorises Mr. Kumar to draw down the funds, and Mr. Kumar drew down 7 or 8 of the 7 out of 8 of the amounts drawn down.
Right. Well, let's have a look at that then, because since the point's been raised, it's actually there isn't actually a power of attorney. That's a misnomer. But the so it's actually what we're talking about here is an account opening form, which is at page 645. This is within section C, so we can look at it now. So this was the account opening form that was completed because there was a specific account for this loan, even though there was an existing banking relationship. This is quite a long document, but if I could invite you to simply scroll through it,
Yes.
because you see that if you go down to 652, for example, I mean, you will see that this is where Mr. Shetty is authorised as a signatory. Yes, you see it says on page 50, there's the signature.
Yes.
And it says any other mandate, as per mandate dated the 2nd of June 2015. This is an old mandate, 2 years previously, submitted to the Abu Dhabi branch, and this is appended. I mean, there's no doubt that the document referred to is appended. Before we get there, let's just look at 656, because there is specific authority to give instructions by fax, telephone, and email. And telephone number, fax number, and email addresses have been given there for submission of instructions. And then again, if you go down to 658, that's signed by Mr. Shetty on the 26th of September. Now, the so-called power of attorney is in fact the letter at 668. Now, I mean, this isn't a power of attorney, it's a letter. It's the bank, it's NEOPHARMA, not the bank, which is referred to this as a power of attorney. That's not what it is. Yeah. But it's a letter from NEOPHARMA saying that they authorised these two people, these two gentlemen, to sign, and there are their specimen signatures. And that, of course, is an earlier one back in June 2015. Again, signed by Mr. Shetty. So, I mean, and they've had this document since the document production of the bank in January last year. So, but I mean, the bank is entitled to rely on this. What's the evidence?
Well, I think what Mr. Krosant was saying was it's not at all clear to him whether this document has been analysed by the fourth defendant's expert.
Well, yes.
And so therefore, if it has been, and it's one of the documents that he says is forged, then this would go to their liability, because if Mr. Kumar was not authorised validly, your point is that the bank, there has to be some evidence the bank knew or ought to have known.
Yeah, exactly.
Right?
There are two points on that. Firstly, he has examined it. This, you see that? Do you remember we saw on page 652? There's a reference to the mandate. The mandate is appended. So this letter of the 2nd of June is an integral part of the account opening document. And we know that Mr. Albar saw that because he as one of the documents he says he's seen. If you go to page trying to see, I mean, it's 1389, the report. Yes, here we go. It's number 7, the original bank operating mandate form, dated the 26th of the 9th of 2017, So he has seen that, and as we know, that form includes the letter at the end, as it's referred to in that mandate.
But what he says about that, signatures appeared on pages 11, 14 and 17 and 19 do not follow same format as they can attribute to a single person writing.
Yes, I mean, I
So
can only guess what that
it's
means.
obviously written, somebody, sorry, is that, am I looking at the right document? That's number 7.
No, that's the one, that's the one. But those aren't the page. I mean, if we go back to the account mandate begins, so the actual is page 668, and I don't think that's one of the ones he's referring to. Yeah. Yeah, that's not one of the documents that the expert's referring to. I mean, he says page 19, for example. Page 19 is the last one he's looking at. So that's...
I'm sorry, where are you finding the page numbers? I can't...
Oh, I beg your pardon.
I
This is the internal page 8. So, for example, page 663, that's internal page 19.
Yes,
and that's it.
Right.
That bears what, I mean, you know,
But that,
whether it's that's
yes.
the Shetty signature. And that, for example, you know, Mr. Albar refers to various page numbers, and that's one he refers to. Page 19 is the last one he refers to.
Yes,
He said,
right.
well, you know, but he's not said anything about the signature on page 668.
Well, how do we know that he's seen the signature on page 668?
Because it is an integral part of the bank opening document, which he says he's seen.
Well, how do we know that?
Because if you look at 652, it refers to it. As per mandate dated the 2nd of June 2015, submitted to Abu Dhabi branch, attached herewith. Oh no, sorry, that's the bank. But I mean, it's this document. It's never been suggested otherwise. This is part of the document, as you'd expect, because they're referring to the mandate, and there it is. That's the letter they're referring to at the end of the document.
Yeah.
I mean, this document was produced to the defendants on the 25th of January last year.
Yeah, right.
So that's that. I want also to look at the payment instructions, because my learned friend is confirmed that he is content to look at those. So he says that they weren't in the form of the utilisation request. I mean, do you want to see that, the standard form? The standard form is Schedule 3, which is at page 227. When I say this is standard, I mean, again, without wanting to give evidence, I mean, this is an absolutely boilerplate utilisation request that you're very familiar in international banking documentation. But it's not really appropriate, because what we've seen in this case is that actually they weren't just borrowing a loan. They were going to be asking either for the money to be paid directly to the contractor, or they were going to ask to be reimbursed against evidence that they paid the contractor. So they didn't use this precise form. What they did, for example, if you look at, page 726, this is the first of the disbursements, which I think my learned friend took you to just now. So this is the first of them. And they say, we've made a payment, it's signed by Mr. Shetty, who's one of the signatories, asking for the reimbursement to the equivalent in US dollars. So very, very clear, what appears to be clear and authorised instructions, so not attracting any duty of investigation. And then below that, you've got the attachments. I mean, what you have 728 is slightly unclear what this is. It looks like it's a list of invoices. And then if your order simply scrolls down, I mean, for example, at 730, there's a whole load of invoices. Some of them of some antiquity. I mean, what seems to be happening is this is the first drawdown, and they're basically using it to settle a number of invoices from the previous year. And there's a voluminous quantity of documents have been provided there for the bank. So obviously they couldn't use the utilisation ratio because the standard template wasn't going to be appropriate. This is what they had to do instead. And if you look at page 729, you'll see that the chief manager of the bank, sorry, 729, I've got the wrong document here. Yeah, you see Mr. Jar, who's the chief manager, on the 26th, he's gone through. I mean, in fact, I think this probably continues the previous. The list, I think, probably looks like a list of the invoices prepared by the bank, slightly incomplete. But there it says compliance of terms and conditions. So Mr. Jar has checked to see whether it complies. Yeah. Yes, we've had the security documents. They've given the undertaking to execute the pledge. Disbursement authority dated, blah, obtained and kept on record. Unit visit done. And a view above, we may release the term loan. And that's what he does. So that's what they do. And then there are obviously 8 of these, but I just want to show you one more, which is at page 832, which is the second. And again, you see, it doesn't come in the form of the utilization ratio request, but it is, of course, just, on the face of it, a completely unsurprising letter, fully authorised by an authorised signatory, this time Mr. I'm afraid I've forgotten the name of the gentleman, but anyway, the second signatory. Yes, thank you. And again, you see, the manager, Bank of Baroda, please note we've made a payment of blah against us, and copies of the attached, authorised signatory with a stamp. And then this is the internal document, note to the Assistant General Manager, issue for consideration. Someone's looked through it. I mean, they haven't just rubber stamped it, they've gone through carefully and they've looked at all these invoices and they've checked at what the terms of the facility are, and then they've concluded that they're compliant. And Mr. Jar, on page 834, has said, yes, we may release it. And then the branch head has sanctioned it as well. Look, on the next page, on 835, against the sanction limit of 34.304, remittance and out will be used for reimbursement of expenses, construction, already incurred. I mean, it's really very thorough, this check by the bank.
Mr. Jar, as you understand, Mr. Jar is the chief manager of NEOPHARMA.
Of the bank, yeah.
Of the bank?
Yes. This is an internal document which says we may release term. Right. He's the chap, he's the bank, and then we've got the senior executive officer of the bank. And then down below that, I mean, you've got yes, I mean there's lots and lots. If you scroll down, there are many invoices that have been submitted to the bank. So again, against this, I mean, what is it about these documents that's said to have raised any concerns whatsoever? It all looks completely unexceptionable to the untrained eye, to the non-expert eye. I mean, what is it about these documents that would have made the bank say, hang on a minute, this doesn't look right, we better check that someone isn't perpetrating a fraud on NEOPHARMA? I mean, it's not been pleaded. They haven't a clue. I mean, they've had these documents, as I say, since last year, and they haven't done anything with them. And there's nothing on the face of them that looks at all surprising or out of the order. On the contrary, that it's clear that the bank have actually looked through it very carefully, and then they've complied with the terms of their mandate as they are required to do. So now, again, I want to refer you to my learned friend quoted something very pertinent in his skeleton. If you look at page 1181, paragraph 23, he quoted a judgment of the English Court of Appeal. If the respondent wishes to rely upon a likelihood that further evidence will be available at trial, it will substantiate its position by setting out, at least in general terms, the nature of the evidence, its source, and its relevance to the issues before the court. That has not been done. I mean, the whole story is so implausible, it cries out for some particulars and for a statement with someone who, with personal knowledge, with a statement of truth, verifying the matters alleged in the defence. And without that, your Honour simply has no basis to conclude there's any defence with any real prospect of success. And I'll sum up when I come to the end with the immediate judgment test. But turning now to the defence of Mr. Shetty. First of all, you've heard various evidence from Mr. Sasheen about the inspection report. Nothing in Mr. Albar's report suggests that he's had any difficulty at all, that he hasn't had enough time. On the contrary, he seems very confident.
Well, is it right that he was limited to 2 hours of inspection in a solicitor's office and asked for another?
I'm afraid I simply don't know the answer to that. But I mean, you know, they went, if that's the case and there was a problem, they could have gone back to the court. They went to the court twice to get orders permitting inspection. And he inspected in June. I mean, if there really was an issue, but there's nothing in the report to suggest he feels himself that he hasn't had a sufficient time to reach his conclusions.
Well, Mr. Shaheen says a second request for inspection was refused. Is that your understanding?
I can't, I mean, I don't have instructions, so assume that was the case, Your Honour. Then if that was refused, then their recourse is to the court. And they've had 6 months. Yeah. I mean, they have been to the court twice to ask Mr. Justice Gross. He made 2 orders, which are in the bundle, relating to the inspection, and the inspection was given. And if there was some problem and it was felt that they hadn't had a fair opportunity, that was the time to go back to the court and raise it with the judge. That hasn't been done. And as I say, I mean, you know, if Mr. Albar had said, I've only had 2 hours, I've had difficulty, that will be another point. But he hasn't himself. This is just Mr. Shaheen on his behalf saying, oh, well, it was all terribly unfair. Why hasn't Mr. Shaheen taken it up with the court? Anyway, but as I say, I mean, the problem with the Albar report is it's not credible in the absence of any reasoning and frankly, its internal self-contradictions. I mean, the mistakes, the references to signatures which don't exist, and I have to invite your lordship to take account of the fact that most of the documents, he says, he doesn't suggest there's any issue, any question of forgery. I mean, it's the odd thing. Some of the signatures he seems to accept are genuine, which throws the whole case up in the air. I mean, look at it, for example. If you look at, this is page 1392, the original sanction letter, there's no suggestion of forgery. The original corporate guarantee, number 3, no suggestion of forgery. The original of the other corporate guarantee, number 4, no suggestion of forgery. Original of letter of undertaking, number 6, no suggestion of forgery. I mean, you know, it's just, you know, if that's right, I mean, if all those are accepted as genuine signatures, where does that leave the conclusions on the other documents, which themselves are innately self-contradictory? On the personal guarantee, he says, well, the signature's not genuine, it may be forged or placed electronically on the document. Now, those things are directly incompatible. I mean, if he looks at it, he says, you know, I've looked at the downward strokes or the pressure, all the usual things that experts do. And he says, I don't think these 2 signatures are the same. That's one point. If he's saying, on the other hand, it's been cut and pasted from a genuine signature, that's a completely different point. He would have to say, well, I mean, it looks like the same, but there's oddities about this, which suggests to me that it wasn't signed, somebody's cut. They're 2 completely different incompatible points. So which is it? You know, we haven't got any evidence or reasoning to support either, but they are fundamentally incompatible points. So that's a real problem with this report. It just is lacking any serious credibility. It's not sufficient to discharge even the modest evidential burden of proof, which rests on a respondent to an immediate judgment application. I mean, again, the point about the restapling. I mean, you know, he's sort of saying, oh, well, the bank could have, you know, unstapled it and restapled it with documents. I mean, that proceeds on the assumption that there is a genuine signature that's somehow been stapled in from somewhere else. So is it forgery or is it a genuine signature that's been fraudulently pasted in or stapled in from another document? We don't know. And those 2 things are not, they're mutually inconsistent. So Mr. Shaheen says, well, you know, he wants to call the further evidence at trial and so on. But I mean, he's had a full opportunity. What would change at trial? His experts seen the documents without any difficulties, expressed a view, a firm view. What could possibly change? He shouldn't be allowed a second bite. He's done the inspection and he's produced a report which is, I'm afraid, utterly inadequate for its purpose. So essentially, I mean, it comes back to my point. This is really a cynical and desperate defence with no credibility. And then so I'd like to sum up by just looking briefly at the test for summary judgment, of immediate judgment, which we could look at 1061 of my skeleton, page 1061. I mean, none of this is controversial because, I mean, frankly, the courts here have recited, as the English courts do, a number of very well-known authorities. But just looking at what I've set out in paragraph 28, Does this defence, why does defence have a realistic as opposed to fanciful prospect of success? No, they do not in my submission. None of them. NEOPHARMA's put in no evidence at all, and Mr. Shetty's put in evidence which is wholly incredible. Same point. A realistic defence is one that carries some degree of conviction. This does not. Not inviting you to conduct a mini trial. I'm simply asking you to have a regard to the evidence which the defendants have had 6 months to produce, and this is the best they could do. You don't have to take at value without analysis everything says the defendant says in his statements before the court. It may be clear that there is no real substance in factual assertions made. That is this case. The court must take into account not only the evidence placed before it, but the evidence that can reasonably be expected to be available at trial. But as my learned friend Skeleton points out, there has to be some evidence, some explanation of what that evidence might be. There's none. Or nothing to suggest that there's anything more that was already before the court. There's the Doncaster Pharmaceuticals case, where I think in that case he also refers to the desirability of disposing of rubbishy defences who've got no prospects of trial. And then finally, the final point doesn't arise because we are not alleging fraud or dishonesty. As I said, it's a plain vanilla claim, a debt claim. The fraud and dishonesty is being alleged by the defendants. And those are serious allegations that require a modicum of proof, which is simply absent. Your Honour, those are my submissions.
Yes. Thank you, Ms. O'Sullivan. Well, thank you, counsel. I think I need to reserve my decision in this case. Tempted though I am to launch into an ex-temp, I think I need to review. Mr. Shaheen, you wish to say something?
To highlight on that paucity of time that expert was allowed, how he was constrained to do the inspection in the same day. My witness statement, page number 599, I was personally present there, and the paragraph number 21, 22 and 23, Your Lordship, in page number 599 of the hearing bundle. I have clearly stated, and why I did not move the court afterwards.
Thank you. Sorry, Mr. Shaheen, this is not an opportunity for a bubba. That note is all that I need. Thank you.
No, my learned friend submitted that we did not take any action before the court. That was a new submission made now. Why I could not take an immediate judgment application was submitted in the meantime. The whole battle shifted to a different castle. There was no possibility for a trial or anything afterwards. It was an immediate judgment application which I had to oppose. And the very foundation of it was shaken also.
All right, well, I'm grateful to counsel for all their submissions, which I will need to consider carefully. I think I need to review the transcript, which I'll order the proceedings. Yes, Ms. O'Sullivan.
Yeah, there is one point I need to raise, which will be called, it only arises if you give it. That's the interest calculation. Sorry, Mr. Sheen, would you mind?
It's all garbled. I wonder if somebody could everybody go on mute other than Ms. O'Sullivan.
Thank you. So there is a third witness statement from Mr. Chowan, which is at page 1033. That is an interest calculation, and it explains. So, Your Honour, you're now muted.
That takes it up to today.
It does, yes. I mean, but now my friends say, well, this obviously is only produced the other day. I understand that, and that's in the nature of interest calculations. You have to do them close to the date of the hearing, so they're up to date. But so it may be that if your Lordship is minded to reserve, you might want to give them an opportunity to make comments on that, for example.
Either that, or I could enter judgment for the amount as at today's date, plus the judgment rate from then on until judgment.
Yes, no, I'm asking you to do that, but you see, this statement calculates the contractual interest up to today's date. As you say, after that, it will run at the judgment act rate. But this is a calculation of the amount due as of today.
Perhaps I wasn't clear enough. What I'm suggesting is that we could do contractual rate up to today, and then even though it's not strictly applicable, we could take as a proxy for the contractual rate the judgment rate until judgment, and then thereafter.
Yes, I'm sorry if I'm being slow. This is about calculating the contractual interest.
Yes, well, I was offering a short, but it doesn't sound like it's going to work. So, what I could do is, I could issue, if I do go down that road, I could issue reasons, foreshadowing judgment, and then give you a short opportunity to put on an additional affidavit up to a particular date, and that date should allow for the defendants an opportunity to reply.
No, I mean, it's fine. I mean, we're content to rely on this calculation, but I think that because when obviously it hasn't been updated for a while, the calculation, and it's not trivial because with the compounding, you really need someone to do it with a you need a computer to do it essentially. So that's what this does, and it also explains the rates that have been applied because LIBOR varies every 3 months, and actually LIBOR was discontinued last year, so there's been a substitution of the overnight rate that is all explained. I mean,
what would you want me to do if I did decide I should enter judgment?
Well, I mean,
about interest.
I would ask you to enter judgment for the sum as set out in this witness statement, because that brings it up to date as at the date of today. But I can see that the other parties only had this, I think, since last Friday, the statement. So they might want an opportunity to put in, for example, a short written submission, take advantage of the fact that your lordship's going to be reserving judgment for a short period.
But what do you want me to do about interest accruing between now and the time when I deliver judgment? Because I've got other things to be doing, and the transcript will take a while. So
well,
maybe 3
yes,
or 4
I can
weeks.
see that. I mean, suppose if it were a couple of months, we'd want to. I mean, that's obviously a substantial amount. I think we would want permission to put in an update at that point. Yes, but this brings it up to date as at the 15th of January 2024, and yes, and then there may be another batch, as you say, between now and judgment.
Well, I'll ask Mr. Sheen. Mr. Costello, do you want the opportunity to put on any evidence in opposition to the third affidavit of Mr. Chahoon?
Yes, Your Lordship, I would like to take instructions from my client to submit it on the last working day. I didn't get any opportunity.
Yeah, you can do that within 10 days.
10 days, yes, Your Lordship.
Mr. Costello, same for you.
Your Honor, I'm having trouble doing the hearing, but if you ask if I want the same, then yes.
Yes, all right. 10 days, Mr. Sullivan. I'll give them 10 days in which to file any evidence in opposition to Mr. Chahoon's third statement. And if they do, you'll have 7 days to put on any evidence in reply. Is that okay? Yes, all right. All right, well, thank you, everybody, thank you all for your arguments, for your contribution to the debate today, which has been very helpful. And I'll reserve my decision and publish it as soon as I can. Right. That concludes today's hearing. Thank you.